right, we're back on the record.
Okay.
Are you, go ahead, sir.
Yeah, so I made a trial binder, because
Okay.
we've been through this before. All exhibits are marked and organized. However, a lot of the exhibits refer to, legal matters. So I made a binder for each individual legal matter so that it's each own exhibit, and then I just refer to pages within those.
Okay,
And
I hear you. Okay, that's how you chose to organize your exhibits. That's fine.
Objection, Your Honor.
Why-
They have to state what legal matters they have copies of, as it may pertain to not only their
they're all
bio.
listed.
Okay, your objection's a little premature because I don't, right, I think he's just explained to me how his exhibits are organized, okay? All right? As he presents them, then we'll see.
Yeah, I was saying, what do you want me, I mean, you're not gonna wanna read all these and say I extracted pages to go to
Okay.
the trial binder.
All right,
And
well,
if you, so that they're not taken out of context, the entire case, every document that is associated with the cases are included.
okay, understood. So you're saying that you have, for different cases, you have the complete case file is present,
Right,
but that as you're testifying that you may present excerpts of documents, but if there's,
page one
right,
sixteen.
gotcha, okay.
Okay, and I'm sure, the court, this is a trial binder.
Thank you.
Taken out of that, the court copies of these to say, you just want me to accept them, so.
Yeah, right there on that table.
And then, if you wanna give me a hand, give him his copy.
Thanks.
Is he entitled to? All two.
Are these all together?
Yeah, that's all it is.
List them right there.
And then those are all. Okay.
All right. Okay, so Mr. Pass, are you going first?
Yeah.
Okay, I'll remind,
And because our cases are so intertwined, I'll be presenting a lot of different things here.
right. I'll remind all of you, you're still under oath. Go ahead, sir.
Okay. So, let's first talk about the Florida incident and walk through the events of that night. The petitioner made a post on Line Dancers on Facebook. I agree with that. It's in my evidence as well. He did make that post on March 3rd. However, I believe he's trying to argue that I saw it. I did not see it. He's also kind of trying to argue that
Objection, Your Honor, hearsay.
within their,
How's that hearsay?
Because he's trying to say that he feels that I'm trying to say that he saw the post. I have never made any admission that he saw the post. I have stated openly that he has contacted people
Well-
and that other people could see the post and contact him about it. I've literally already answered that. So why he's trying to state other facts isn't a proper objection.
Okay, no, that's more of an objection based on mischaracterization of your testimony, so you're not saying that. Why don't you did you see, let's just stick to the facts, okay?
Yeah, well,
Did you, so
he's
you're,
arguing that because of this
Yeah.
post, I was made aware that he would be at the Dallas
Right.
pool that night.
yes,
Okay. Now, I mean, contained within the post, there's nothing in there. The Dallas Bull is one of 3 suggestions made by people of where he could possibly go dancing in the area. Also mentioned was the Stockyard and the White Buffalo. They say he could have went to any of those. There would be no way for me to know where he was going to be on what night. Moving on to Exhibit A and O.
and can I,
Or AO.
let me stop you for 1 second, though.
Sure.
Mr. Rorick, you presented that Facebook post, I had your mom read it. Okay, that's how you actually presented it, but you didn't give it to me as evidence. Were you intending to admit that into
Oh, I
evidence?
didn't? I thought I did.
I don't think
Oh, you
so.
know what? My mom might have actually took it with her.
I just admitted it.
And both sides have a copy of it, so I'm sure one of us can get a copy to you about it.
Yeah.
Right, because you handed your mom some documents, but only the U-Haul picture did you actually give to me. When she was reading things, when you didn't admit them to me, I thought maybe it's because you were intending to go over it again during your direct. Because you understand, you were just having her read things that she didn't create or weren't sent to her. So I was thinking you were going to testify as to those documents.
Yes, Your Honor, I did testify to those documents. I didn't read them aloud, but I said that I made them and that's how I
Okay, so
contacted Neil
that's-
Spain.
That's fine. I mean, she read it into the record, so I have what it said. Okay.
I mean, he
I was
also
just letting you
did-
know I don't actually have the physical document.
Well, I can go get it because my mom's probably the one that has it because I don't recall getting it back from her.
Okay, fair enough. Go ahead, sir.
Well, let's say, on March 3rd, at the time that he made the post, there was no way for me to know that that was going on. I was in the middle of packing and moving. Let's say, on Exhibit AO, which is dated March 2nd of 2021, I made a post about how the movers had changed the terms of the contract that we had agreed to in Indiana in the 11th hour, which sent me scrambling at the last second to go ahead and find new movers and secure a moving van at that time. I made this post on Facebook, but I wasn't actively on Facebook at that time. I was actually pretty busy in the 11th hour getting ready to move. That's also demonstrated in Exhibit AP, where I posted that that was my last day at work was on March 4th.
Okay.
So, and I left after that evening to move to Florida.
Okay.
So I was really busy during that time, not really paying much attention to Facebook other than talking with a few friends here and there about my upcoming move.
Okay.
Exhibit AQ. Let's see, and he even admitted this in his testimony that, or his mom did.
Mr. You have the trial binder. I think it was on top if you want to follow along.
I don't need to see it. I can.
Fine. Okay, go
If I
on.
need to see something, I'll look at it. I promise.
Okay.
Let's say, he's argued that he came to town to help his sister move, but on the night of the event, he was here on his own. The rest of the family wasn't here. They were in Washington, D.C. He wanted to come to my area and where I was living in Florida to go line dancing.
Objection, Your Honor. My sister, and they know this because even Joe Bouncer Atkins and my father have openly admitted to them that my sister moved to St. Petersburg, Florida. That's why I was going to be in the St. Petersburg area. Instead, I decided to go to the Tampa area, and I testified to why I changed my mind of going to the watering trough because it was permanently closed. And
Okay,
that I
you're
was
just
somebody
giving me
else.
testimony. You can't just keep interrupting because you don't like his testimony, okay?
You know, we didn't interrupt.
Objection, but okay.
Well, it's an objection, but your objection is based on the fact that you disagree with his testimony.
Okay, so objection for his characterization of it, Your Honor.
Anyway,
Sir, it may be best for you to just testify as to what you factually knew about and what you were doing instead of trying to say what you believe the evidence shows he was doing too, okay? Because that's where a lot of his objections are coming from,
okay.
because he
AR.
disagrees with your characterizations of what he was doing,
Yeah,
okay?
in Exhibit AR, as early as February 16th of 2021, I had posted on Facebook that I was moving to Florida. As you can see from the comments in the exchange with Michael Durbin on February 16th post, I clearly indicated I'm moving to the Largo, Florida area. In addition to the February 16th post, also in the comments section of a February 23rd post, Exhibit AS, I indicate also in that post where specifically I am moving, Largo, Florida. I say, if we can go back to Exhibit AN, his post on Line Dancers on Facebook, when he claimed that he was coming to Florida and was looking for a place to go dancing, he specifically targeted Largo. That post was made on March 3rd, when my posts were made in February of where I was moving. And while my Facebook may be private, the fact that I tagged some people in that post on February 16th indicating where I was moving to, that would make it available to be seen by the public.
Objection, Your Honor. It's hearsay and speculative. That's pure speculation.
Overrule. He's just testifying that he believes that because he tagged people, he's not saying you saw it, okay? He's just saying that he believes it could have been seen by other people, okay? That's just his belief.
Pure speculation.
In Exhibit AT and AU, I post specifically pictures of me at the Dallas Pool on February 12th and on March 9th, or on February 12th. Two posts from February 12th showing me at the Dallas Bowl. The pictures clearly indicate that I'm at the Dallas Bowl. Even on page 2 of Exhibit AU, in my comments, I posted a picture of the Dallas Bulls logo. Again, on that specific post on February 12th, I tagged Troy Meyer and Rachel Kute, which, even with my profile being private, when I tag somebody, apparently it makes the post available for others to be able to see it. So, I didn't know that at the time, but. And then Exhibit AV, on March 6th, I moved to Largo. I had been searching for a job, let's say, at the end of 2020. The company that I was working for had informed me that they had suffered some financial issues in relation to COVID, and they would be shutting down the office that I was working in. When they told me that, they suggested, you know, we got another 6 months before we're probably going to close this office, but you might want to go ahead and put your resume together and go ahead and start searching. We want to give you plenty of enough time. So I sat down and started identifying areas that I wanted to move to. It included Virginia. I was looking at crime statistics, stuff, cost of living, that type of stuff, and I had identified 5 areas that I wanted to move to, the Tampa Bay area being one of them. I started interviewing for the job that I have now in January of 2021, was offered the position near the beginning of February of 2021, which prompted my trip to the Largo, Florida area in February 12th of 2021, which is where those pictures came from. So then I gave my company notice that I would be leaving, worked out my notice, and on March 6th of 2021, I moved to Largo. Again, Exhibit AW, Dory Bauer McCormick, patron at the Dallas Bull, had posted a recap of the night's events at the Dallas Bull, which March 12th just happens to be a Friday, the same night that we encountered one another, same night of the week that we encountered one another. And on that post, she said that she made a new friend and tagged me in it. We'll go ahead and skip AX and say you want to stick to just the facts, that's fine. Okay, I'm going to walk through what happened the night of March 19th. Let's say on page 6 of Exhibit AJ, Steve Paz Civil Protection Order, item number 4 clearly states, respondent shall stay away from petitioner and not be present within 500 feet whenever the protected person may be found. It goes on to state, if respondent accidentally comes in contact with protected persons in public or a private place, respondent must depart immediately. Doesn't say anything about who was there first or anything.
Objection,
So
Your
if
Honor.
he's talking
This is
about
only
that this was an
speculation, but there's
incidental
multiple
contact.
case law that states the exact opposite. There's
Okay.
case law that states the exact opposite.
You're testifying as to what your protection order said.
What my civil
Okay,
protection
that's-
order states.
What's your objection? It says that in his order, no?
It does, but were we in the state of Ohio? No. We were in
No,
the state of
but
Florida.
he's just saying this is what it says, okay? Just let him testify.
Okay.
So if I'm understanding what the civil protection order states, even if it was an incidental contact, it wouldn't matter who was there first. Just approaching me at the bar was violation of my protection order as it is
Objection,
written.
Your Honor. 21 CM 5782 TAC Alpha literally states because Mr. Paz came near me, and this is as per the judge, not me, that he came near me, not I went near him. At prima facie, at face value, he was there was no violation of the protection order. This has already been answered. If he has not appealed, he has not objected, he has not filed any lawsuits against me to state to disprove that a fact.
What I understand you're testifying to is why what your interpretation was and why you thought that night that you didn't have to leave. Whether you're right or wrong,
Your Honor,
I'm not deciding that. He's trying to explain to me what was going on in his mind that night. Yes?
Yeah.
I
He
understand.
can do that, okay?
Your Honor, he cannot state that
I'm not letting him verse me in the law, okay?
That's not
And tell me, what I'm going to let him do is let him explain to me what his thought process was that night, okay? Overruled. Go on, sir.
Okay, so I went to a place that I had normally started going to after moving there. I hadn't been there long, but it was a place that I had started going to. I'd been there twice basically. This was gonna be my third night at the location. And it was a place that I enjoyed going to. I walked in, I went to my normal spot of where I would be, and I gotta be honest with you, the last thing I expected was Mr. Roy to be there. He was sitting on a stool with his back to where I was standing, and that would be the last person I would have expected to be sitting there. I was just kind of standing there, enjoying myself, listening to the music, waiting, for some friends to arrive, and all of a sudden I turn around, and he's in my face yelling at me. I was here first, you need to leave. I was a little stunned at first. I couldn't understand why somebody was in my face screaming at me, and it took me a minute to register it's Mr. Rory. So he told me that I need to leave, and I've read this thing thoroughly, and I said, well, wait a minute, I don't think that that's how it's written. And then he got upset, and he went and he grabbed security and brought security over, and he was...
Objection, Your Honor, perjury. He told the city of Columbus or the random caller sheet that he had 2 security cars come and break us up. That's perjury, right there.
I didn't say that. I never said
That's
that.
what
I don't
Columbus
know
wrote
what he's
down.
talking about then.
That's it. You have it in evidence. The Columbus already stated that. That's perjury, tamper with evidence, criminal charges.
Overruled. Keep going, sir.
Can't overrule
Okay,
that.
so-
I can overrule it because all you're doing is just disagreeing with his testimony.
I'm not disagreeing with his testimony. He's self-contradicting himself. You have a random caller sheet with him.
You
stating
gave
that.
me your side. He's giving me his side. I'm the trier of fact. I'll determine if anyone's lying, okay? Go
Your Honor,
on.
I am just going to motion for a continuous for an appeal of Ohio Judicial Conduct Rule 2.11 disqualification of a judge because he literally stated that, and Columbus has no choice but to side with me on that. I'll be going to the prosecutor's office and demanding charges be filed prominently to him since he's given it to me in evidence.
Well, your request for continuance is overruled. Go ahead, sir.
Okay, so he went and got security and brought security over, and he was telling them he has a civil protection order against me, which is true. He said, I was here first, he needs to leave. So the manager came over as well, and the manager said, yeah, I don't know how this works, but I think we've encountered this once before. I think he's right. I think you need to leave. And I was prepared to leave. As the manager had said that to me, Mr. Roig started celebrating inappropriately in the mind, or in the opinion of the manager, which the manager said, okay, you need to stop doing that now and go away. And then he went away. I don't remember if security took him away, if he walked away voluntarily, I don't know. I know that he went away and went outside. So then the manager came back over to me after he had been removed from the situation, whether voluntarily or involuntarily. And the manager apologized to me and said, I'm sorry that, he acted like that. He said, but fact remains, he said, if he was here first, I think he's right. I think he needs to leave. And I said, okay, fine. I don't want any trouble. I'll go ahead and I'll leave. I don't want to deal with this. I don't want to get a bad name here. I'll go ahead and I'll leave. As we turned to leave, another patron that was sitting there said, I don't mean to jump in here and interrupt, but I work for the sheriff's department, and he's right. If he has a civil protection order against him, he's the one that needs to leave. And the manager said, okay, look, I don't want to open ourselves up to any kind of lawsuit or anything. He said, how about this? He's outside. Why don't you go over and wait in the billiards area? The sheriff's department's already on its way. When they get here, let's have them sort it out. I said, okay, that's fair. Okay. So I went over and I, complied with his suggestion of waiting over in the billiards area while he was outside. After about 10 minutes, I believe that the manager was probably getting tired of having to dedicate security outside to keep us separated. And he called me over and called him over as well. And he was in the middle of making a suggestion of, look, why don't you both just stay and just avoid each other? And something happened with Mr. Roig where at that point the manager said, okay, I've had enough of you. You need to leave. You're not welcome here anymore. You're banned from the bar permanently. Mr. Roig said, well, I have an open tab. He said, okay, fine. I'll walk you in. We'll close the tab, and then you need to leave. After he left, I was in contact with, the other people that have, get lawsuits and other legal matters from Mr. Roig, and said, Mr. Roig is at the bar. And they said, you need to contact the sheriff's department. So I stepped outside, and contacted the sheriff's department, called them, and they said, we already have a deputy on the way, just wait out front for them to arrive. I said, okay. As I was waiting for the sheriff to arrive, Mr. Roy came back and again approached me. He was screaming something at me. I couldn't understand what he was saying. It was something about, I think both of us are going to jail tonight or something to that effect. I can't say exactly what he said. I couldn't understand him. But he was intercepted by security at that point, who told him, look, we've asked you to leave. You're not welcome here. You need to leave or we're going to press trespassing charges against you. And Mr. Roy refused to leave and waited for the sheriff's department to arrive and took him into custody. And at the end of that, the sheriff came over to me and asked me, okay, well, what's going on here? And I gave them my opinion. I didn't know exactly what was going on. I think Mr. Roy is, trying to claim that I knew he was there to help his sister move because his dad had told me that. And I don't disagree with that, but I didn't know that to be a fact. I don't know for fact if his sister is
Objection,
moving
Your
to
Honor.
here.
They never brought up my father to any jurisdiction ever. That's literally tampering with evidence and witnesses in multiple court cases. and
Okay,
criminal
so
cases.
when you cross-examine him, you can ask him that, okay?
Okay.
Right, go on.
So, I didn't know it to be a fact that he was actually there helping his sister move. I think that it was suggested by his father, but I didn't know that to be a fact, or specifically where in the area she may be moving to. I did find out later that she wasn't even there at the time that he came on his own accord and went out to a place that I go dancing. And then the sheriff asked, I showed the sheriff, look, I have a civil protection order against him. He's violated it. I'd like to go ahead and file a report. And they told me, basically, look, he's been taken into custody for trespassing. He's going to spend the night in jail. Why don't you just go ahead? Everybody's tired. Come down to the sheriff's office in the morning and go ahead and file a report on the civil protection order violation. I said, okay, which I did. The next morning I went down to the sheriff's department and I filed a complaint about it. They attached it as an addendum to the trespassing, and it kind of got lost. Later, he attempted to sue Hillsborough County, which caused them to pull that police report back out and take a look at it, and that's when they discovered, oh, wait a minute, we have a civil protection order violation complaint in here that was never addressed. And that's
Objection,
when
Your
they
Honor,
went
speculative and
and
hearsay.
filed,
Okay, well, it is hearsay.
What's that?
He's objecting on hearsay, okay? None of those people are here to testify, correct?
Okay.
Well, it's not just only that, but that was not any order of what happened with the Hillsborough County. They didn't pull it because I didn't file a lawsuit at that time. I already told them I was just filing a lawsuit, which is proper according to the Florida state law.
Okay, let's keep going.
Okay. I said, that's what happened in Florida. Okay. So when he was released the next morning for the trespassing charge, and they dropped the charges. He is 100% correct. Hillsborough, when they contacted me to question me about the civil protection order violation that they later discovered had gotten missed, they asked, he had contacted my daughter while he was in Florida. He contacted my daughter back in Columbus and violated her civil protection order. And
Objection, hearsay, and speculative. I was found not guilty, and she tried in 2019 and also received no charges and no warrant was issued. Already covered it.
You said in March, you're still talking about in the March date okay. He's not talking about something in 2019.
Well, no, in 2019, the case, there was a warrant that was dropped, and then also the content that he just brought up, that after that incident was also dropped and found not guilty.
That's a mischaracterization. It wasn't not guilty.
Okay, well,
It was not
listen, you can cross-examine him. You can't just keep interrupting because you disagree with his testimony,
I'm not
okay?
disagreeing with his testimony. It's factually wrong.
Even if it's factually wrong, trial procedure doesn't work like this, okay? We can't, after every sentence, say, no, that's wrong. Here's what really happened, okay? You present your side. He presents his side. everybody gets to cross-examine each other to try to prove to me that somebody's lying, okay? You don't just get to make a statement that that's wrong, okay?
Your Honor, the courts have already stated that what he was saying was wrong.
I know, and when you cross-examine him, you can cross-examine him about that. Go ahead, sir.
Okay. Well, anyway, when he did contact my daughter, he.
Well, how do you know that?
Huh?
How do you know that?
She sent me a
Okay.
copy of the message.
Okay.
And in that message, he instructed her to pass a message along to me as well.
And you're nodding your head, yes, so you did that? Okay.
Yeah.
All right.
I mean, the civil protection order, in its entirety has been introduced into evidence. And so he's not allowed to contact any of us, either directly or indirectly, through a third party. As technically.
Objection,
in
Your
defense
Honor,
of Mark
Columbus
19, he
Columbus
violated my
Leargo
civil
and
protection
Hillsborough
order
County
3
already
times.
said no because it was court authorized contact via 19 CV 4494. You can even contact Judge
He's-
Essex about it.
He's saying that he believed that you contacting his daughter was a violation.
Yes, and
Not-
the city of Columbus has already stated that that's not a violation, and Mr. Pass had nothing to do with his daughter's violation.
Let's
She
just
said
skip
that.
ahead. So was he charged for sending
Yes.
Miss Pass?
Yes.
And was it dismissed?
Eventually, it was dismissed after, how long did it go on?
A year and a half.
Year and a half.
Okay, so it was dismissed. All right, so I get it. He made contact with your daughter, so you're trying to explain how the Ohio charges
He's trying to
arose.
say he's
Okay.
found not guilty. He wasn't found not guilty. The case was
Charges,
eventually
yeah,
dismissed.
Dismissed.
That's not guilty.
No.
And
It's
not
not.
competent.
Objection, Your Honor. Note, they just brought up competency. Ohio Judicial Conduct Rule 2.11 and Ohio Professional Conduct
We're
Rule
getting
3.
nowhere. Everybody stop. This is what I was afraid of, that this would devolve, like, sir, you brought a case here. Do you want me to consider whether these people are stalking you? They're entitled to present a defense.
Again, Your Honor, I'm allowed to object due to
You are
misconduct.
entitled to object, but what you're doing is you're objecting to everything they say because you just don't like it and you think it's full of falsehoods and untruths. And I'm telling you, those aren't proper objections.
Okay, Your Honor, explain this to me. How is it I think and feel when the courts have literally stated factually that's not true?
Then you present that evidence
That's what I'm trying to
in
do.
rebuttal. No, you don't interrupt and just say,
Okay. Oh, man. Well, then carry on.
well, I'm trying to let them carry on, but I'm trying to get you to understand that if you think that something they're saying is not true, you can object under relevancy, hearsay, those kinds of things. You can't just object and say, that's just not true. That, I'm telling you, is not a proper objection.
Because they synonym to hearsay. Not true is hearsay.
No,
Or,
that's not.
or speculative.
All right, go ahead, sir.
Okay, move on to the next section.
You know what I'd actually like to know? I want to jump all the way. Did you like, because a lot of what caused all this is when you liked his TikTok and you said you did that. Why would you do that?
I'll address that. So
Yeah.
we became aware that he had filed for civil protection orders against us. Obviously, I do my due diligence in preparing for the case. So, I have to go on and prepare for my case.
Okay.
During that, I checked his social media to see if he was posting anything that would be considered a violation of the civil protection orders, because it clearly states he can't make any posts about us or anything along those lines. If you go on his TikTok, I accidentally liked the video. It was not
Doesn't matter.
intentional. I apologize to the court. I apologize to him. And to be quite honest with you, I'm more upset about it than anybody else, because if he doesn't have a like from me, he's the emperor without clothes. There's no other argument that he's brought in here that is relevant.
Okay, because part of his case is that he feels like
It was not.
this side is trying to bully and harass him, taunt him into violating the protection order. And part of it is like he's saying, you're going onto his
Right.
social media presence, liking things, making contact with him. So do you see his point where he feels like, I'm not supposed to, you guys are afraid of me. I'm not supposed to be anywhere near you. Why are you on my page? That's partly why we're
Yeah,
here.
that's the reason I was establishing with his mother that the like happened after he had filed.
Fair.
And
Okay.
I was just preparing my case. Like
Okay.
I said, I was upset about it. I'm embarrassed about it. I apologize to the court. I apologize to Mr. Rory.
You don't have to apologize to me. I just wanted to know because you had earlier admitted, yes, I liked it. And so I was just curious
Right.
how that all
It-
came
it
to be
was
about.
Totally incidental, it was accidental.
Okay,
Yeah.
all right, because you explained to me your side of what happened in Florida. Basically, what Mr. Rourke thinks that you are part of a conspiracy, that you're withholding things, you're not being forthcoming, you've thwarted all of his other ancillary litigation, correct, sir? That's why you're here, because, do you have a response to that?
Yeah, I say when he sues us, he does it under things. Say he uses deceptive tactics to go ahead and sue us. He'll sue Nio's crew. Nio's crew is not a legal entity. We don't call ourselves Nio crew. He calls us Nio's crew.
Objection, Your
Okay.
Honor. We've already asked and answered this, that Mr. Pass is a member of the Club Dance Veterans. I've
Again,
never said he was a part
it's
of
not a
this.
legal business or entity. It's not an LLC. It's not a partnership. It's not a corporation.
Mm.
It is a Facebook page. That's all it is.
Okay,
It's
so
a-
he
it's
brings lawsuits,
against non-entities.
Right.
And we file for dismissals against the fact that he didn't sue a legal entity or person.
okay,
And in the one specific case that he's talking about, it was one of the first things he filed against us. He sued Nio's crew. I was a little bit concerned that I don't know what can be done if we don't answer it. He's gone to paralegal school. Let's say he's a little bit more educated on the law than what I am. So I filed an answer. I applied
Okay.
for an account. I filed an answer clarifying for the court that we are not Nio's crew legally, and identified anybody that he might be able to associate with Nio's crew, because I could see from previous cases that he had filed, when people didn't answer them, he immediately on the 30th day goes and ahead and applies for a default judgment. We didn't want the court to somehow get confused because nobody replied to it, that a default judgment should be issued, and then him later name us after the fact. I don't know what the court can do. I was clarifying for the court, we are not Nio's crew. Judge Page, in her ruling, stated, after receiving the communication from Mr. Paz, the response from Mr. Paz, and talking with the plaintiff, have determined that Nio's crew is a nickname. It's not an LLC, it's not a partnership, it's not a corporation. Therefore, I am identifying Mr. Paz and the other individuals as non-parties in this case. And then she went on to say in her ruling, and it's in here, that because Mr. Paz is a non-party and not an attorney, so it was clear to Jayza Page that I'm not an attorney, I never presented myself to be, that she can't consider any motions that I made.
right, okay, I understand.
So us thwarting any legal action he's taken against us, he hasn't technically taken any legal action against us. He's tried to deceive the court into calling us something else, not naming us, sending it to addresses that we have no association with, and then we have to scramble around.
Objection, Your Honor.
trying
110
to
North Spring
defend
Road was already
ourselves
confessed by
against
Ms.
these
Stark that was a legal and lawful address that they are associated with.
Okay, I understand.
Yeah, so him earlier saying that, he sent notification to 110 North Spring Road and it got declined is because he sent a lawsuit to Nio's crew to Megan Stark's home. She's not Nio's crew, so she declined it. So,
Okay,
however, he's clearly identifying us as Nio's crew, am I correct? I think that he's more than made it clear that when he's talking about Nio's crew, he's talking about us. That doesn't make us a legal entity that we can be sued. It's just what he calls us. And us acknowledging that we know who he's talking about when he's saying that doesn't allow him to go ahead and just bend the rules of the law. He has to name a legal business or entity or person to sue. We are not a legal entity under Nio's crew that has the ability to be sued.
okay.
In addition to that, I say sometimes when he discusses Nayo's crew could include other people. As you can see in Exhibit A, right into that section, when he sues Nayo's crew, he also names other people besides Megan Stark, Megan Paz, and myself. He names Riley Brown, he names Allison Zen, he names Brandon Phillips. Later on, he talks about Columbus Dance veterans, saying that I belong to that group as well, or I belong to Columbus Inline Dance Collective. There's all these different groups. Club Dance Veterans and Columbus Inline Dance Collectives are just Facebook pages. It's a place. It's a Facebook group where individuals can go and share pictures, videos. Megan James and Jeff James can go ahead and share
Objection,
the
Your Honor,
dates
they're
of
literally
upcoming events.
sponsoring and presenting events under that name of Columbus Inline Dance Collective. They've also done it under Club
He
Dance
said,
Veterans.
did you need something?
I just wanted to clarify, since he keeps saying that these entities, no one, this whole presented and what have you thing, we have never created any type of promotional material ourselves. All that material is created by the actual bars themselves. They distribute that. We are not paid to do it. We do not pay to promote it. They choose the wording that is on there, and some choose presented by, some say posted by.
Okay.
But it is truly
Thank
just
you.
a Facebook page that
Objection,
anyone.
objection,
can
Your
post
Honor.
on.
She literally stated in the Facebook post that I've already given to you that we are in the house. Let me repeat that. They can't be a separate, or they can't state that that's not their name in real life if they're literally
Okay.
on the premises.
There's a dispute. He thinks that these names that appear on the Facebook page on promotional materials makes you a legal entity. You're saying it doesn't. That's a dispute, okay?
Well, not only that, Your Honor, but they've also been served both on Facebook and through their attorneys and frankly, come please.
Okay, I get it. You think that these are viable legal entities that can and can't be
No,
sued.
that's not what I was about to say.
Go ahead.
I was saying that they were already served with a cease and desist that I have filed my intent to trademark. That means they gotta take that Facebook down or can't give me the logins and stuff.
Okay, and that's a dispute for another court. I'm not here to resolve trademark infringement. You do get that, right?
Yes, I understand
Okay,
that, Your
all
Honor,
right,
but
go
they're
ahead.
gonna say that that's just the Facebook name. If I have the trademark, they can't legally and lawfully.
Okay,
go
and
on.
maybe you're right about that, but that's not grounds for protection order.
Okay.
Go on.
So the rest of the orange text and the CPO violations is say there's a laundry list of Facebook posts in here that he posts about NIOs, sometimes even passing messages along in his Facebook status updates, where he's passing a message along to
Objection,
NIOs.
Your Honor. Magistrate Judge
Yes.
Pamela Erdy already ruled on this.
Disguised
As long as I don't use their individual names, I'm okay to post whatever I want to. They've tried to mom and pop that before with Miss Wire. It didn't fly in that courtroom either.
Yeah, I say, but I mean, most of the time we're not reporting this to anybody. I think it just goes to show that we're pretty.
Objection,
we're
Your Honor.
showing
They
a
already
lot
were
of
told that they're
patience and
not
tolerance
allowed to
with
report
this
it.
allowed.
That's testimony. That's not a proper objection.
That's not
All right.
testimony. That's case law. Jesus Christ.
He's disguised.
Okay, that's disrespectful, sir. If you don't have to like my rulings, okay? But that doesn't give you the right to be disrespectful.
It's not being disrespectful. You have.
Did you just not say Jesus Christ under your breath? And you don't think that's
I
disrespectful?
didn't say under my breath. I said it loud and proud for everybody here.
Oh, okay, but you don't think that's disrespectful? Again,
Not when
another.
there's a precedent that you have to go by in CPO court. They say that they have a legal and lawful CPO. In that legal and lawful CPO, they were told, let me repeat that, told and ordered by Magistrate Judge Pamela Erdy in multiple court cases, saying that he's okay to do that. So try to no, I got this. So trying to say, well, we showed him empathy and sympathy. No, that's not showing you me empathy and sympathy, because you were already told that's okay. You have to go appeal that. Did they appeal that? Did they object to it? No. That's been asked, answered, and ruled upon. They have to abide by that. They can't claim empathy and sympathy and other things on it. Nice try. Carry on. Jesus. This is why I always get in trouble, because I know more about the law than everybody, because I have access to Westlaw and LexisNexis.
But you don't know how to make a proper objection, sir, because that wasn't it.
Okay.
Go ahead.
Okay, let's just go ahead and move on to the next section. The legal processes. And Exhibit B, U, BD, and BW. These are just some examples of some of the subpoenas that we have received for various cases. As you can see in the context of some of these subpoenas that we have been sent, we feel that some of the things that Mr. Roy asked for and some of the subpoenas is him attempting to take advantage of the fact that he has a legal matter to invade our privacy. In the description of documents to be presented in Exhibit BU, he's asking for any and all documents associated with the sale of my home. I'm not really sure how that relates to a civil protection order hearing between him and his dad. It seems like Mr. Roig is just trying to take advantage of the fact that there is an existing legal matter, filing a subpoena, and then trying to invade my privacy through that subpoena. If you look on Exhibit BW, again, this is a subpoena that he sent to Megan Stark, and in what he's asking for all texts and Facebook messages to and from Rodney Roig and Randy Nicole Conenberg. Again, this is just short of trying to use a subpoena to tap her phone. Like, he wants any and all private messages. He's not entitled to those. Those have nothing to do with Roig versus Roig's civil protection. Again, in BX, a civil protection or a subpoena that he sent to his father. He's asking for all text and Facebook messages from Mr. Paz, from Megan Paz, and Megan Stark. This is related to a criminal matter that he had with the Franklin County or the City of Columbus in relation to violating a civil protection order. And even while he's being prosecuted for a criminal matter, he's attempting to invade people's privacies.
Objection, Your Honor, purely speculative. He's already admitted that he contacted Rodney Roig, and I provided text messages with Rodney Roig stating that Mr. Pass took a photo of me and was Brady's Rules and Giglio's Rule evidence. So to try to say it's a vision of privacy after he knows how to look up the law is just purely perjury and speculative and hearsay, Your Honor.
Okay, so to explain that.
Okay, so here's all you can testify to is that this is how you perceived that he was trying to get personal and private information he wasn't allowed to get. I'm not resolving, Mr. Rourke, I'm not taking his testimony as to legal arguments, okay? I'm not sitting here saying, yeah, he's right, this was improper. He's just letting me know from his perspective how he perceived this. He didn't think you were entitled to it, okay?
I understand that was purely speculative. That's an objection. It's noted, move on.
Again, after I answered the complaint that he filed against Nio's crew, immediately he ended up filing for discovery. And in Exhibit E, page 43, you can see he's asking for Steve Paz's work excuse to his work in the state of Virginia for missing work to testify in Roig versus Roig. My personnel file at work is not anything related to any case whatsoever. It's a fishing expedition, and
Objection, Your Honor. I'm required to have his new address, which he just stated that he intentionally and recklessly did not update once before, after not doing that in Florida also.
we intentionally did not update our address. We're not required to do so.
Yes, you are,
We
so
don't
I
have
can
any
know where I
actions-
can and
we
can't
don't have
go.
any actions against us.
What statute authority? Because I understand your point that if he doesn't know where you live, how would he know he's violating it?
It's
That
not-
I get.
There's no
but-
statute. It's the United States Constitution, cruel and unusual punishment.
Oh, okay,
'Cause it's cruel and
gotcha.
unusual
Okay,
punishment if, like I said.
sit down.
I'm just trying to.
No, sit down.
Okay.
So you don't have an actual statute or code that says he had to give you his address. You're just saying that it's
It's
an
called
inherent
a s-
unfairness. If you
It's
don't
not-
know where he lives, then how would you know
It's
if
not
you're
just
violating?
unfair. It's not just unfairness. It's cruel and unusual punishment, equal protection clause, and due process right to a complete defense, as well as the precedent known as the necessity and duress defense.
Okay.
We were advised by the prosecutor in the cases not to provide our updated addresses to Mr. Roig, and that we weren't required to do so. There's no statutes against, or there's no rulings against us or anything where we're required to update the court on where we live. Like, there's nothing, we have no requirement to do that. And I believe earlier Mr. Roy even said said something about when I illegally moved to Florida. I don't understand.
I never said legal. Objection, Your Honor. Hearsay and perjury. I never said legally. I said
He
illegally.
said that.
All right, well, what's your point?
Yeah, so he's saying that we didn't update our addresses. Yeah, we didn't, purposely. And saying we were advised not to do so.
Okay.
Yeah. Moving on, so, Exhibit CA and CB, you can see that after unsuccessfully filing to have the civil protection order modified in 2019, while being prosecuted for the violation of Megan Paz and my civil protection orders, the petitioner continued his harassment undeterred by unsuccessfully filing for civil protection orders against Megan Paz and Megan Stark in August of 2021, which we've already introduced those cases as an argument. The subpoenas and unsuccessful attempts to modify the existing civil protection orders in the petitions for new ones aren't the only attempts the petitioner has made to continue his harassment of myself, Megan Paz, and Megan Stark through the court system by making it look like it's for legitimate legal reasons when no legitimate legal necessity exists. Exhibit E, pages 4 and 5. Despite the petitioner being unsuccessful in his attempt to sue Steve Paz, Megan Paz, and Megan Stark, the petitioner turned around a year later and attempted to sue them again with civil case number 19CV004494 against NIO's crew and Club Dance veterans. While the petitioner didn't sue any legal entity or individual, it's clear in the context of his filings associated with the case, his intent was to sue Steve Paz, Megan Paz, and Megan Stark, as well as possibly other individuals, which may or may not include, and we're unclear on this, Jeff James and Megan James at that time. Yeah, so we're kind of unclear on if it included Megan James and Jeff James. I think they are mentioned in the context of some of the filings and stuff. Exhibit C, pages 4 and 5, Exhibit M, pages 6 through 15, Exhibit N, pages 5 through 26, and Exhibit AI, pages 4 through 10. When the petitioner was unsuccessful in his attempts to sue Steve Paz, Megan Paz, and Megan Stark, we believe that he decided to sue the dancing venues we like to frequently go to. We believe the petitioner viewed the scenario that even if he didn't win the lawsuit, he would create such an issue at those venues that the venues would decide to permanently expel us to prevent the petitioner from targeting them with lawsuits. So even if the lawsuits against the venues were unsuccessful, he could still potentially negatively impact our lives by robbing us of the
Objection,
opportunity
Your
to
Honor. They
protest
already know about
something
premise
like that.
liability and the CPO, and I've already addressed that. There is a case law that's stating third-party crimes being committed on those premise means that they're not allowed to be there or not allowed to be patrons or employees. That is the law, and I know that because it's in the CPO against me as well.
Okay, so I understand your testimony. This is why you were sending either litigation or threats of litigation to these entities. And this is not, I mean, Mr. Rourke certainly hasn't confessed to you that this is frivolous litigation he brought. This is just your opinion as to what he's doing, right? Correct?
Right.
Your Honor,
Okay.
it can't be his
I mean-
opinion when he has legal case law that he can go look up and clearly knows how to do and states the exact opposite, just like the inherent risk, which also brings up the addresses. The inherent risk that they go to in a bar.
See, part of this problem with, being in the CPO court, though, is because you and your mom are testified how you feel like they're ganging up on, harassing, bullying you, and their defense is that they feel like, no, you're bringing these lawsuits for ill motive. Now, I'm the trier of fact. I'll decide who's proven what, okay? But I understand, because, yeah, normally in the court of law, when somebody's speculating or saying, I believe this, it doesn't count as facts. But this is a little different when we're talking about how people perceive
Your Honor.
harassment, okay?
He literally confessed that he intentionally did not update his address. That means he knew the inherent risk that I may or may not be in the same city or same state as him. Thank you.
I understand your point. Go on.
Okay. It's not
So, kind of arguing that he's just being a good Samaritan. I said, why is it always centered around us? Right? Just informing the bars that they can't do this. So, like he's doing them a favor, but, it's always about us. Anyway, in Exhibit C and D, CC and CD, the argument is supported by the fact that the petitioner has contacted multiple people we know and venues he believes we frequent to tarnish our reputations. Additionally, we believe that the messages to the people we know was an attempt to get our friends to distance themselves from us, to prevent being targets themselves. This also would potentially eliminate any support we may be able to receive from any of our friends.
Objection, Your Honor. I
either
already
as witnesses
confessed
or
that I was
otherwise,
trying to
with
get
the
them to
message
speak
to
up
the
about the
dancing
incident,
venues
so
we
that's pure
believe.
lies.
I
Hearsay
allowed
and
you to
perjury.
testify.
Perjury and hearsay and speculative. I already confessed that it was to
Hang
get them
on.
to speak up. That has nothing to do with what you just said.
We gave him the opportunity to present his
I
testimony.
I understand, Mr. Ward. You have to let him testify. You can't just keep interrupting him because you think he's not telling the truth. Okay?
That's again not thinking he's not telling the truth. I already confessed why I contacted those people. That's already stated on the record and asked, even by Megan James.
This would eliminate the support we may be able to receive from any friends, either as witnesses or otherwise. With the messages to the dancing venues, we believe the intent was to get us expelled permanently to avoid the potential lawsuit from the petitioner. And this behavior began in February of 2020 when the petitioner contacted two of my friends, Sean Mayer and Barry Harp, after I posted a picture of me with them at a gun range. Shortly after making the post, the petitioner started sending both of them threatening messages.
Objection, Your Honor. They were not only not threatening, but I was working with.
The messages that I have exchanged with those
I
two
was
individuals.
literally working with Sean Vegas Myers, and he was talking with me about the Nios instances at Tequila Cowboys, as he knows the people there while we were working, and he never disclosed that he knew Mr. Pass, not once.
Okay, but he's just saying that he got it. You sent them messages. Do you agree that you sent them messages?
I did send them messages, but they weren't threatening. In fact, I even told them that they needed to speak up, that Mr. Pass was not allowed to
Well,
represent them
did
in
you,
court.
Mr. Pass? How did you see the messages? First of all,
I'm sorry?
how did you see the messages?
So Sean Meyer contacted me and let me know that he was being contacted by Mr. Roig about me, that the message between me and Sean is in here. He said that, he sent a picture of us all together at the gun range, and he was talking about some stuff. He didn't understand what was going on. I explained the situation. He said, oh, okay, that makes sense. He said, yeah, he rambled on about both of them too, and Barry. Now it makes a bit more sense. And then I contacted Barry to let him know in Exhibit CD, hey, Sean just started receiving messages from Mr. Rohrig, so he's probably going to contact you as well. And then Barry responded and said, yeah, thanks for the heads up, I've never heard of him. And then I said something back to him, and then he said, I don't remember him, but he just sent me a text. I replied asking him what's up. And then I said, yeah, I figured it was coming, basically. And he said, yeah, he's texting me now. So, if his argument is he knew Sean Meyer, why is he contacting Barry Hart too? I said, there's no reason to contact Barry Hart. So he's just reaching out to my friends. So, when there weren't any consequences, reaching out to our friends and stuff, I said there weren't any consequences to those previous communications. The petitioner began another smear campaign in July of 2021 by sending messages to Helen Camerata, the administrator of Line Dancers on Facebook, and Maurice Rowe, the line dance instructor at the Stockyard in Holiday, Florida. Unfortunately, Maurice deleted the messages that was sent to him from Mr. Rohrig, and he just blocked him. Mr. Rowe didn't want involved in any of it, but he was disturbed by the messages so much that he did tell me about it. And then I communicated that to Jeff, because Jeff and Maurice, Jeff used to live down in Florida, and he and Maurice were best friends. And then Jeff asked him about it too, and Maurice confirmed to him as well. Yeah, he was sending me some messages saying he's going to send prosecutors after me and some other crazy stuff. Because Maurice deleted his messages, I was only able to post the message exchange between me and Helen where she describes what happened. She didn't send me a copy of the message. She doesn't want involved, obviously, and I have to respect that. But I did include the messages that she was sending me describing the situation, and in it she said, it's a little scary when someone who was a previous member in my group says he wants some information on a member, or he'll send prosecutors to me for that information. For some reason, he was blocked in my group, not sure why. I unblocked him, and now he says he won't rejoin because you're a member. After he was wondering why he was blocked and was upset about it. I told him it's not my place to share information about a certain member with another member. Facebook can remove my group. I never had such a situation happen. Considering both messages were sent to Helen Camerata and Maurice Rowe around the same time, I think it's reasonable for me to assume that both messages were very similar in context. So he's, in Exhibit CF, it appears the petitioner again is attempting to engage in these same types of activities in July of 2022, right around the time that he filed another lawsuit against Flanagan's Dublin, Columbus Inline Dance Collective, and others. Rodney Rohrig reached out to me and asked me, do you know the name of Kyle's probation officer? I said, no, I'm sorry, why? Did he do something? He said apparently he's back to trying to sue everyone again. In Exhibit BD, this is where recently, in November of 2022, he's reaching out to associates of Columbus Inline Dance Collective engaging in an active smear campaign. So you can see this in Exhibits BD, CG, CH.
Objection, Your Honor. I already covered this, stating, and I quote, that they need to speak up because I had no idea they were associated with them. They've even proved that in their own emails.
Okay, all right.
Actually, where is that?
All the rest of the exhibits in this section are all dedicated to the messages that he has sent, where he's actively engaging in some type of smear campaign against us, let's say, accusing us of crimes, trying to encourage others to participate in his harassment, through threat that if they don't
Objection, Your Honor.
that
I've already
multi-head
brought up, and they
file
even brought
lawsuits
up that it
against them.
states that they were operating illegally with them. It can't help that they did that. That's premise liability, third-party crimes. That's legal and lawful to state that they have to do, or they face a
Say
lawsuit.
there is no legal business to say they are independent contractors. It is a standard of business by millions of companies across the country every year.
Okay.
It's not illegal.
Okay.
Okay.
Then we can go on to the next section. Exhibits BD, CI, CK, and CL. I believe it's more than clear that the petitioner has been trying everything he can think of to tarnish our reputations and defame our character. I feel that it's more than demonstrated that in the previous exhibits, like BD, CI, CK, and CL, accusing us of crimes, telling people we're doing all kinds of crazy stuff. This is also clearly demonstrates in excerpts from the petitioner's various lawsuits. It appears that part of his legal strategy is to just attack our character by constantly accusing us all of crimes. His assertions are obviously false.
Objection, Your Honor. I was
exhibits
literally found not
provided
guilty in Florida due to his
are-
false allegations.
The exhibits
None.
provided are just a few examples
Okay,
of the.
so, but what is your actual objection? You just, because you already given me your testimony, so it's basically that.
Case law, Your Honor. I already gave you 21 CM 2519 TAC Alpha and 21 CM 5782 TAC Alpha. I was found not guilty of going down to, guess what, smear his name and reputation. I was found not guilty of harassing and stalking him. I was found not guilty of trespass. No, it was found not guilty, the injunction one, because I sent a, guess what, FSA 3.190 C4, more commonly known as the C4 motion, which is a motion to dismiss, as I was found not guilty under prima facie because you came near me.
I'm gonna weigh the testimony, okay? So overruled, if I think he's not telling the truth, then I won't find his testimony credible, okay? Go on.
Contained in these excerpts from different various lawsuits, they're all contained over there in their full context. These are just a few examples of the consistent court filings containing language that attacks our character and accuses us of criminal activity. Meanwhile, the petitioner appears to be admitting to his own criminal activity by clearly stating that he drives after consuming 5 or 6 beers while on medication.
Objection, Your Honor.
You're
There-
writing,
Objection, Your Honor. A person's BCI, BIS, whatever the body thing is, A2, that's from I sent that to the prosecutors and in a court motion, so he shouldn't even have access to that.
it's in a memorandum that you filed in another case.
Is that where you got it?
Yes.
In what case? What's the case number? in the case name.
What exhibit are you on?
Exhibit AO, or AD, I'm sorry, it's smaller printing. Exhibit AD, which is AD.
And what is the case number and case name that I said that in? You're gonna list an affidavit, you gotta put the case
It's
number.
okay, he can tell him the case number, all right?
AD, State of Florida versus Kyle Rory, County Courts, in and for Hillsborough County, Florida Criminal Division.
Again, so you're not allowed to have that evidence.
Why?
Are you a party to that case? Nope.
You didn't have to be a party. Was
Are
it?
you a Florida judge? Show me
I'm
the
gonna
Florida
answer
law.
questions to you.
Show me the Florida law that states that he was allowed to have that. Because he can't state any
You
Florida
show
law.
me the Florida law says he's not allowed to
I
have it,
don't-
because you
I-
have the burden of proof, not me.
I don't have to have the burden of proof. He does. He's the one that brought it in. All I have to do is prove reasonable
Public-
doubt.
It's public record.
It's
If
not
you're
public
making the
record.
objection, you have the burden to prove your objection. Where did you get it?
Public record. Public-
So you went online and it was there?
No, it wasn't just online.
It's just online.
Well, what's the relevancy? I mean,
And he's accusing us of all these different various
Right.
crimes in all of his legal filings on top of sending out letters. It's like, he's just engaging in.
And
this
again, Your
widespread
Honor,
conspiracy.
objection. He literally said that because I drank 5 to 6 beers, I must have been drunk. That doesn't prove that I was above .08.
Well, no,
So
I
again,
said that
prove it.
You admit that you drink 5 and 6 beers while on medication and still drive home.
Yes, and I can legally and lawfully do that when I'm, guess what, below .08.
Okay.
Just like with, guess what,
All right.
weed, below .08. That's legal. Prove I was over .08.
Exhibit E.
Mr. Paz, I would focus on allegations against you, okay? Not things that you think he's done that, okay? Because that's not gonna help.
And since we were on the subject, I'd like to take the opportunity to address the petitioner's accusation of me practicing law. He claims that his claim is absurd. According to Ohio Revised Code, in order to be in violation of the code, I would have to present myself to be an attorney. I simply answered the complaint that he had filed in order to prevent him from being able to go ahead and,
Objection, Your Honor.
File
Judge
a-
Green
a
cleared this
judge-
up under ORC and unauthorized practice of law, and the 10th District Court of Appeals will back me up on this also because Judge Green tried accusing my mom of, guess what, unauthorized practice of law. Because guess what, where his signature was, if that was my motion, it literally said, that slide dash, S, slide dash, and then my name. Now, I can do that and have my mom go file it. Mr. Pass cannot put his name down while saying he can represent Ms. Pass,
I
Ms.
didn't
Pass,
say I
and
was
Ms.
representing.
Yes, you did, Bucko. That's why the case got reopened.
I stated that these individuals are not NIO's crew.
Go ask Judge,
To
go
clear
ask
up
Judge
with the
Page.
court.
Go
So
ask
as you can
Judge.
see
So-
on Exhibit E, page 165, under Section 2, non-party motion for contempt, say, Judge Page clearly identifies us as non-parties and says, Steve Paz is neither an attorney nor a party to this case. His motion for contempt is denied. So if it's clear to the judge that I never presented myself as an attorney in that case,
It doesn't matter if the judge said that because the 10th District Court of Appeals overruled her and reopened the case. Yet again,
So all we're doing is arguing the facts, okay?
I'm not arguing the facts. He's
Yes,
trying
you
to,
are.
he's trying
So, is
he-
that true? Did the 10th District overrule Judge Page?
Yes, I
Oh, no,
already
okay.
gave you the sua spussante motion. I already brought this.
I don't have any record of.
I also, yes, you do. You have the e-service. You have the e-service and electronic access to it under my cases in your
After I
Franklin,
was
Florida County.
identified as a non-party to the case, we didn't show up for the hearing because we were identified as non-parties. I started ignoring the case from that point forward because we were identified as
Objection,
non-parties.
Your Honor. I already covered this. Megan Stark was confronted in 19 CRB 016888 while she was on the stand with a sua spussante motion that it was reopened. And in fact, when you go talk to Judge Jazzy, since she's right next door, even though she's probably not registered right at the second, she will even confirm that she issued another sua spussante motion after November 30th of 2020 to, guess what, prove that I proved that I can serve them properly. And she stated that. On top of that, I even told Mr. Pass this in person at Dallas Bull, which is why he brought up 19 CV 4494, stating he's the only one that thinks that case was still open. No, I wasn't, because I have Mrs. Hummer, Judge Jazzy Page, myself, my mom, Isaac Grinsky, and whatever her secretary name is. So that's literally just lies right there.
I don't know what you. Neither of you are presenting just factual testimony, okay? All you're doing is arguing back and forth at this point.
I just proved by fact.
No, that's just your testimony as to how everything went down, okay? So basically, everything you say is gospel, everything he says is a lie, right?
No, I gave you a suis puissante saying on November 30th, 2020, she issued a suis puissante motion stating that it was going to be on trial for 17th May 2021. I even gave you a court transcript saying it
I
was
did,
wrong.
I saw that it's that.
That's
Because
factual
there
evidence.
wasn't any parties in the case on the defendant's
Right,
side.
but
The case
how
moved
is that
forward.
meaning that he's menacing you?
Because he literally stated that I was the only one to think that case was still open.
Okay,
And they
how
were-
is that menacing? Because maybe he's wrong. Maybe I can say that's wrong because the judge thinks it's still open too. How does that make that menacing though?
How's it
For-
make it? Because they were committing a criminal act against me by stating that. Because he could have went and fact checked it. He didn't go online to his Franklin County e-file system and check it.
Okay, so you think because he had made an incorrect statement of fact that now he's stalking you.
No, the reason why he's been stalking me is because I turned his daughter down. 2, his whole group has been stalking me when, and I quote, I was doing a line dance that only I know in the entire state at the time. While at Tequila Cowboys, he saw Riley Brown trying to copy it. Now, according to them, he's gone to the Dallas Bowl for years, even by Miss Stark's confession.
Okay.
He would have known about that line dance. Now, did he correct Riley Brown? No. Then there's a group,
Ever since then, he's just engaged in this campaign of
him
harassment.
and his entire group.
Okay.
I literally had to leave Flanagan's Dublin in 2018 because they were harassing and stalking me while I had an active lawsuit against them. Why I wasn't doing anything to provoke them. I literally walked to a
Okay,
friend.
let's get back on track because where you were focusing on was part of his case is that he says that you are somehow part of the conspiracies, you're engaging in authorized practice of law. And your testimony to me is that when you make filings and stuff, sometimes you make facts that apply to the other individual's name, but that you never represented yourself as their attorney.
No.
That's what your testimony is.
Right.
Okay, so you would deny that you committed an unauthorized practice of law, and you think he did.
No, Your Honor, he knows he did because he also failed to state that he was a licensed notary in the state of Ohio, which means he knows he's not allowed to put his signature down on stuff like that.
Okay, all right. We can go round and round all day, but okay, your testimony is you deny that. Okay, what's next?
So the other things that he tries to tie to us as, withholding evidence or whatever. Let's say Exhibit E, page 69. There's a message exchange in here between him and Brandon Phillips. This message exchange was sent.
Objection
to me.
here say the second party is not here to be cross-examined under, even Magistrate Judge Pamela Erdy has already told them that kind of evidence is not allowed unless Brandon Phillips and Mr. Pastor present.
But I'm not testifying about what's in
It doesn't matter. You're saying what's in the message between me and him. Is Brandon Phillips here? No, that's evidence that's rolled out because I was illegally denied, if that's true then, according to you, to bring in Rebecca Horn, now Rebecca Adkins,
That's true.
evidence.
Because I've let in a lot of hearsay because I haven't had a lot of hearsay objections. But yes, messages that you received or sent, you can present testimony to that. Messages that other people received
I'm
or
not
sent is
testifying on the
hearsay.
content of the message.
Okay, so what's your purpose of presenting it?
My purpose for presenting it is the message was sent to me, an excerpt was sent to me from Brandon Phillips when we had the original CPO hearing. And I presented it in my testimony at the time. Later, he comes back and says, you're withholding evidence, you didn't present the entire message exchange. I said, I wasn't a party to the entire message exchange. I just presented what I had access to that was sent to me. He's claiming that we're withholding evidence. He was a part of the conversation. If he felt that it was relevant, he has access to the entire conversation. We're not withholding evidence. He could have presented it.
Objection, Your Honor. Ask him when I got the evidence. At trial. And I can't take evidence off my phone without them taking my phone. Thank you. You know this.
We weren't withholding any evidence. So we just presented what we had. As in, we weren't party to the conversation.
Oh.
I don't know what the rest of the
And
conversation.
Okay, so you weren't. His point is because your point is that they're conspiring to thwart your other litigation. He's just explaining. Your point is that was not a malicious intent on your part. That I'm only going to present this and not the whole thing. You just presented what you had.
Right.
So that's your side.
Right.
Okay.
And
He's allowed. You can disagree with him all you want. He's explaining that I'm the trier of fact. Go ahead.
I was about to bring up the fact is that He said that we haven't withheld any evidence. Yeah, you have. You have withheld Columbus Inline Dance Collective's entire, let me repeat that, entirely since 2018 when I started all this. You never even brought that up in any motion, any evidence, and I haven't asked for any and all discovery.
Yeah, that's our next part, as a matter of fact, that's the very next page. And so, while we're on the subject, petitioner accusing Steve Paz, Megan Stark, Jeff James, and Megan James of various criminal activity. Let's go ahead and take a look at some of the other accusations. As previously presented, the petitioner has publicly asserted that Jeff James and Megan James are running an illegal company by operating an unregistered business. Columbus Inline Dance Collective are running an illegal business, Columbus Inline Dance Collective, to make money teaching line dancing at Flanagan's Dublin. First of all, Columbus Inline Dance Collective, as in Exhibit CM, is a Facebook page. That's all it is. It's not a business. It's simply a group on Facebook created by Jeff James and Megan James as a page country line dancers can go to visit to see dates and times of upcoming line dance nights and events, a place for users that are members of the group to share pictures, videos, dances, and other postings with like-minded friends about the hobby that they share together, and a place for Jeff James and Megan James can post announcements like line dance workshops to members of the group. Jeff James and Megan James are not employees or agents of Flanagan's Dublin. They're
Objection, Your
independent
Honor. Respondent
contractors
superior. They are
for
agents.
Flanagan's
Hang
Dublin.
on, sir. First of all, he's not objecting to foundation, but I will. You're testifying as to, I don't know how you know them, how you would know all this about them, okay? And if they're gonna testify, then they can explain what their role is, okay?
Your Honor, they know about Respondent Superior because of all the lawsuits, including the current one against Flanagan's Dublin and Columbus Inline Dance Collective. It literally states Respondent Superior because I'm the one that typed it.
Yeah, you're saying that they are liable. They disagree, okay? I can't
No, I'm
can't
not-
make everybody agree,
I'm
all
not
right?
saying that
Go ahead, sir.
We'll move on. Exhibits CR and CS. This isn't the first time that the petitioner has attempted these tactics. It started with making publicly posting accusations he knew to be untrue. I believe his previous activity was a major contributing factor in Judge Sheeran's decision in granting the original civil protection orders against him in the first place. Clearly, the petitioner did not learn from his lesson from this because he still continues to do it. As you can see in Exhibit CR, the petitioner publicly claims a female accused Steve Paz of child abuse and domestic violence.
Objection, Your Honor. This has already been used to get a CPO against me. He can't bring it up because they've already asked for that stuff to be not allowed due to the dismissal.
Well,
with
that is
prejudice.
fair. We aren't gonna relitigate because I'm not gonna let him, I did not let him present evidence that the CPO that is in place against him was improperly granted, okay?
Okay.
So, I
I
understand.
was presenting because you talked about history.
You didn't want
Yeah, it's
to
fine, it's fine.
relitigate, you didn't want him to
respect that.
relitigate that, so then how is that fair for you to get to relitigate it if when you won on that ruling that we're not gonna relitigate whether that CPO should have been granted or not, right?
Okay, all right, that's fair.
Okay.
I respect that. Okay, so we can move on to Exhibit CT. To clarify my reputation with the court, I'm supplying background checks I ran that I paid for with my own money through two separate independent background check organizations. As the courts can clearly see on these background checks, I have no criminal history. I don't even have any traffic violations. On the copy of my driver's
Objection,
license
Your
that
Honor.
is
He has
provided,
multiple traffic violations. In
it
fact, he has
clearly indicates
unregistered.
a safe driver status. So the petitioner is
Doesn't matter if
just
it's safe driver.
recklessly attacking an upstanding
You
member of
cannot say
society
that you have
with an
never had a
exemplary
ticket in the
record.
state of Ohio when you have. You've had unregistered tags. You haven't even updated your registration a bunch of times.
That's not, I don't understand what you're doing. Again, you're just throwing accusations out.
I'm not
That's not an
throwing
objection.
accusations. I objected.
You are.
It's called perjury. Is he under oath?
Yes.
Did he just say that he's never had a
But then
ticket?
what
and
you
he's
do
not-
is you cross-examine him as to what you think you can
Okay.
prove.
I didn't
He
say I never had
said,
a
so
ticket.
this background check said you have 0 criminal records, you're not on the national sex offender list, you're not on the most wanted list, okay.
Right, and say motor vehicle report is clear, county searches are clear, national search is clear, global watch list clear, sex offenders, say social security, trace, say everything is clear, even my driver's license, which is included in Exhibit CV, clearly states that I have safe driver status on my driver's license. So, no active moving violations within, I think, what is the past 7 years or whatever, so I never said I never had a ticket. Obviously, I've had a ticket in the past. I'm 50 years old. I've had a ticket at some point in time. But in recent memory, no. I say my record is 100% clear, and that's the worst that anybody could ever find on me is that I once had a couple traffic tickets. Moving on. Let's see, in the interest of trying to move things along, and say I don't want to revisit a bunch of stuff.
Well, the other thing too is if you revisit it, you open the door.
Yeah.
Because if you want to prove to me that he did all these things and that's why,
Well,
and that he's harassing and stalking you in the past, that opens the door for him to defend himself to try to prove he didn't do those things.
sure. But
Okay?
okay, so let's go ahead and move on to the orange section. Okay, near the end here. Let's say in section G, same issues elsewhere. The petitioner would like to lead you to believe that he is being picked on, ganged up on, and harassed. He has attempted to argue that we are responsible for getting him banned from certain facilities. Truth of the matter is, the petitioner's behavior at various facilities.
Hang on, what?
Can I go take care of a quick medical issue with my sugar?
Yes, go ahead.
Continue.
Okay, are you sure?
Yeah.
Okay, yes, please, go. Okay.
The petitioner's behavior at various facilities have led to him getting banned from nearly everywhere he has gone.
Objection, Your Honor.
As you can see in Exhibit CW and CX, even before meeting any of us, the petitioner posted on his own Facebook back in 2015 that he had gotten banned from the Bank, a dancing venue in Virginia. His own words. The petitioner may want to blame us for getting banned from Tequila Cowboy because...
Objection, Your Honor. He's bringing up terms from 2015 when A, we didn't even know each other, and 2, it was supposed to be brought up during the original CPO. If he didn't bring it up and he knew about it, that's his fault. Because he also contacted my ex-wife, you could have told him that. And he already brought up my ex-wife. That's inadmissible.
I know, the relevancy is he's responding to your allegations that they've been bullying you, harassing you, and he's saying that you have a history of being banned from places. That was his point,
Okay, well then I also object under perjury because he's not confessing that he was asked to leave the Dallas Bull and failed to do so.
Right, I get it.
We've been over that.
Yeah, we went over, I remember what his testimony was. This is part of his case, is he thinks you're not owning up to the fact that you were asked to leave first. Okay?
I did say that.
And you're not allowed to say that, so that just kills the other thing you just said because you didn't leave the bar when you had to.
Let's just keep going.
All right, Exhibit Y, page 37. If the court needs any more proof, the petitioner getting banned from facilities are his own fault and not the fault of anything any of us are doing. Please refer to page 37 of Exhibit Y. In response to the petitioner's lawsuit against Steel Creek Whiskey Company, a dancing venue in Washington, they clearly indicate in November of 2019, the petitioner was involved in an ongoing verbal altercation with one or more of the patrons. Management claimed that they received several written requests. from the
Objection, Your Honor.
petitioner
Hearsay. Is Still Creek
individuals.
Still Creek here? Again, hearsay. Still Creek is not
There's
here.
court testimony here in this.
Well, you're just presenting to me a public document you received, that you,
It's court
not that you
document.
received, that you obtained?
Yeah,
Okay.
Again, Your Honor, he has to state how he obtained that because that is not online for anybody to get.
you can request it.
Did you find it online?
I
Or
requested it.
you request, okay. From the
Yeah.
clerk?
Yeah.
I mean, it's Washington, the Superior Court of the State of Washington, so,
No, that's Pierce County.
and, I mean, this is what somebody wrote in their trial brief, okay? It's not all that relevant to me, because it's not a judicial finding
Well,
against
you're-
him. I understand that you're
What
showing me
you're
it's proof,
describing is perfectly mirroring what we think.
I hear you.
Your Honor, not only
But
is that,
it is hearsay because it's just them, I mean, I know it's a public document, but it's just them alleging these
no,
facts.
Your Honor, that's not a public document.
Okay, well, I'll agree with you, it's not a public document. My point was more that it's just somebody's version of facts, but this is not a judicial finding as to what the facts were, okay?
Again, Your Honor, I actually can bring something up that also proves mincing by stalking. Why don't you ask Mr. James here how he knows DJ Super Dave?
We're not,
DJ Super Dave?
Are you asking me?
Oh, I'm asking her to ask
it's
you.
not,
I don't know who the game is.
okay, all right, we're not even to your part yet, stop. Mr. Poss is the one that's testifying. Is there more?
Yeah, let's say in Exhibit AA, let's say, he was requesting civil protection orders from other people in Washington. All the same issues that he experiences, like, the point is you can see from these documents, all the same issues that he's experiencing here in Ohio, he experienced in Washington where he moved out there. We had nothing to do with that. He's doing civil protection orders, getting banned, like, all the same issues. And say, we had nothing, it's following him. And these people are obviously people that he filed lawsuits against out there as well. So, mine got to be a little bit too thick. I had to move to a second one. And we do have some. I'll be very brief, and we can just go ahead and move on. We do
Well,
have,
let me stop you for a minute. Miss Stark, are you okay?
Yeah, I'm okay.
You sure? Okay.
yeah.
The brief sugar crackers you don't make.
I prepared for this, it's okay.
Yeah, so, we have what we feel are legitimate concerns about the behavior escalating to physical violence and stuff like that. We can see from if you look at Exhibit T, page 30, in response to one of his lawsuits, again, public record, it shows that there was some disciplinary action for violence while he was in custody.
Objection, Your Honor. There was no disciplinary actions for what I was in custody that resulted from violence.
Okay. Well, that would be relevant if you had a petition against him pending, sir, okay? Because we're here to whether you're menacing him, all right?
And then there was one last thing. Where is it? Yeah, on Exhibit I, page 264, let's see, this is during one of the arraignments. Mr. Michael Shaw, on behalf of the city of Westerville, this is Michael Shaw speaking with the court on during the arraignment. Said, Mr. Rohrig is an out-of-state resident from Washington. He's actually been in frequent contact with the law firm of Metz, Bailey, and McLaughlin, to the point that they would actually like a stay-away order from the law firm. They have
Objection,
actual
Your
general concerns about their
Objection,
safety.
Your Honor. They were committing prosecutorial misconduct under United States v. Osmak, which is also a Florida law, Florida case law of the 11th Circuit Court that literally states verbatim of improper remarks, and if improper remarks prejudicially affect my civil rights. They never told the judge, and I quote, that they were being sued, and Michael Shaw and Ms. Whitehart were not allowed to be anywhere near my case. So all that is stricken from the record.
What is stricken from the record?
Anything that they just said about Michael Shaw and what he said about that they fear for their life of me, because I'm going to be asking him a very serious question and cross-examine that's going to blow that out of the water anyways, but I'll just write that from the record.
Sir, again, I understand why you're presenting all this material, okay? But the fact that other people have bad things to say about him is just not all that relevant to me, okay?
I'd say it goes in line with everything that we're presenting too.
I understand, but I'm here to determine what's going on between you folks, okay?
Yeah.
So let's just stick to that, because it's just, all you're doing is creating argument for him on appeal, okay? Because it is hearsay. None of these people are here to testify, to verify those facts to me. I understand other people have said things about him in legal documents, but that doesn't make it true what they're saying. Do you understand where I'm coming from? Okay? But I understand your point is that you're saying that, look, many people have had issues with him clearly, okay? I do understand your point, all right?
Before I go ahead and close and just go ahead and let Jeff James go ahead and do his.
Well, I'm gonna have to let him just cross-examine you, because I can't have all of you present hours worth of testimony. It's cleaner if he just cross-examines you before they testify.
Okay.
Do you understand what,
Yeah.
procedurally, it makes more sense now that you're done testifying to let him.
Yeah. Yeah, that's fine.
All right, go ahead.
Oh, my cross-examine fine? Mr. Pass, you stated that you testified in Kyle Rohrig v. Rodney Rohrig, correct?
Yes.
Did you happen to state to the court at any time or all the way up till now that you knew that Rodney Rohrig filed not only a false police report, but also disproves your CPO that I never willfully nor assaulted my father, Rodney Rohrig.
Let's see, just because no charges were ever pressed doesn't mean that you didn't assault him.
So you're
You
stating that-
assaulted him.
So you're stating
He
that
did file a police report.
you're stating that there was no letter issued by the prosecutor stating that that was not a crime.
I mean, they didn't press charges against you, but it doesn't mean that you
They
didn't
didn't press.
assault him.
Wait, did you say they didn't press charges against me?
Yeah, they didn't press charges.
Really? So there was not a domestic violence restraining
There
order
was.
and a police report saying there was a warrant issued?
He filed a police report. To my knowledge on the whole subject, he filed a police report against you for coming to his house and assaulting him.
Objection, Your Honor, because I never went to his house and just started assaulting him. The police
Okay,
report
he
didn't say
said that to his knowledge that that's what the police report said.
Yeah.
Whatever, Your Honor. Okay, you stated that I got banned from the bank in 2015. Were you in the state of Virginia or privileged to that information?
No, it was on, you posted it.
Yeah, I posted that I was not lawfully banned from that place.
Yeah,
Yes or no?
you said that you weren't lawfully banned. You said you were banned.
Yeah, because they illegally banned me. Now the next question: did you ask my ex-wife about that ever?
I have never spoken with your ex-wife.
But members or friends of yours have.
Okay, well, ask them.
Please state why the city of Columbus stated that I'm keeping you from your daughter and Miss Stark from moving on with their lives when you knowingly got on TikTok, not even 2 weeks later, 3 weeks later on my TikTok.
Yeah, you filed a lawsuit against us, and in preparation for getting ready for the court today, I did go ahead and do a search on your social media platforms, and accidentally, inadvertently, like one of your TikTok videos. It was an accident, and I apologize.
And how did you incidentally do that when the like button and heart buttons are on the far bottom right?
It happened in my pocket, actually, is what happened is after I closed the video, I put it in my pocket, and then the phone came back on shortly after. And when it came back on, I was on somebody else's TikTok completely, so it had cycled through. Otherwise, I probably would have went back and unliked it, hoping that you had never seen it. But I became aware of the fact that I accidentally liked it when you filed something with the court stating that I had. I hadn't known that I had at the time.
Yeah, just like according to you, you didn't come near me in Dallas Bowl.
Like I said, you were sitting there with your back to me. You were the last person I expected to be sitting there.
Oh, I can clear on that because I had
when
no
I was
clue you were
standing
there.
there, you approached me after you saw me.
Objection, Your Honor, that's hearsay.
No, he's testifying to what what he saw happen. Okay,
Okay.
how's that hearsay?
Uh,
Because he said how's that hearsay?
how's it hearsay? Because not only does he know that to be a lie, but I went and grabbed the security guard. He watched me do it.
Yeah.
But I did
You went
not.
to grab a
Okay,
screwdriver.
Keep going.
Okay.
Next question.
Oh yeah. That's right, Westerville. Please say to this court, who is Mike Kutzik, and why have you guys still to this day not reported him for being an illegal police officer in the state of Ohio?
Mike Kutzik was, to the best of my knowledge, a member of the security staff at Tequila Cowboy, a place that we would go dancing at. I don't know anything about him. I know that he's a police officer now, and I think back then he had told me that he was trying to become a police officer while he was working as a member of security at the bar. He was a friend in passing. I don't know everything about his personal matters. And I don't just report people for crimes I don't know are crimes. Like I don't know that he's engaging in anything illegal, so.
Okay, you answered.
You also stated that you somehow got the Washington Rohrig v. Still Creek. How did you get that?
I contacted the court system and put in a request.
And how did you know to contact what court?
I did a search. I did an online search through Google. And additional cases popped up showing what cases he was involved in, and I made a public records request.
Can you
in
please state,
preparation for today.
can you please state to this court why you failed to state that that case was ongoing while I was doing 60 days illegally in jail in Hillsborough County, Florida? On your case, no less.
I mean, I'm here to present my case, not yours.
I'm not asking you to present mine. You heard that. I'm going to ask this by question. On Valentine's Day 2022, in Judge Jeski's courtroom, did you hear Judge Jeski verbatimly state, and I quote, "I recuse myself and I am sorry, Mr. Roy, for not allowing you to play that video"? Yes or no?
I don't remember him apologizing. I do remember him recusing himself.
And have you reported him or the prosecutors, or state, what do they call them, state attorneys down there? Or the,
Why would I do that?
So no, you haven't. Just,
No.
that's yes or no. No, you haven't, right?
No.
Okay.
I'm not going near him, I'm just doing this way so I can go this way. Coolers, we'll get to that in a second. While this is waiting to load. Oh, man. Please, Mr. Paz, state why there is contradiction that you stated to the city of Columbus, and this is as per Columbus, not me, and it's already presented in evidence. So you can't say that it does not exist, and it's definitely not hearsay. Why they stated that you said that 2 security guards came and separated us, but yet then you self-contradicted yourself by stating that I went and grabbed the security guard myself.
What?
According,
I think what I testified actually said both of those things, that he went and got a security guard, they came on over, they believed that he was right. And they're like, you know, not sure, I'm not a lawyer, I don't work for the police department, I think that we've encountered this issue once before. I think they're right, I think he's right, if he was here first, you're the one that needs to leave. And
And
that's
tell
when
them-
he started celebrating.
Okay.
then explain to this court why you have never stated that to anybody. Not even
I
the courts.
stated it earlier.
No, not, okay, let me rephrase that. Why have you not stated that to anybody or any courts prior to this court hearing?
I haven't been in any courts.
Yes, you,
What
Fine.
court?
you just admitted to being in Judge Jeski's courtroom.
I was present, I wasn't giving any testimony.
You don't have to give Alright, Mr. Pass, I'm gonna,
Was I supposed to interrupt the judge?
alright, Mr. Pass, I'm gonna,
So it's you never felt you ever had a duty to come forward with that information?
No.
Like there was never a time where, like you were never asked
Right.
about
I
it?
was present during the hearing, but I wasn't a part of the hearing. It's between the prosecutor and Mr. Roy, so me interrupting would be inappropriate.
Okay, that's his response.
because I also said the prosecutors, but okay. Alright, Mr. Pass, I wanna show you this little video clip of the body cam footage from that night. I wanna, since you are clearly trying to say that you're an expert of looking up the laws and doing your due diligence, please, I want you to explain why you never talked to my dad or any bouncer about why what this bouncer did was illegal.
He's gonna say that I violated the CPO because I just made Facebook posts.
Your Honor,
about it.
it's
If
one
he
of the-
doesn't do that, then he's in
Yeah, it's
violation
one of
of
those
the
two
CPO.
videos.
Okay, well that's fine. All that's in Ohio.
It's the
My
one
thing
labeled
is-
Alexandria, or you aren't the only one. The other one's Coolidge.
No, like leave. You were trespassed, so leave. I'm not gonna arrest you over petty stuff. Like you really, I don't understand why you're still here.
I stay here or you arrest me. I'm giving you your options.
Hold on 1 second.
Oh no, that's evidence. That's evidence. That's tampering with evidence.
Why have you never asked the bouncer about that?
Am I supposed to testify why the bouncer?
No, I didn't. No, I never asked why the bouncer did that. I asked why you never contacted a bouncer, knowing various of them and contacting all these bars. Did you never ask or ask any law about what that bouncer was allowed to do what he just did?
I don't understand the question really. Listen, my only interaction with the bouncers after that incident was I had the opinion that the United States is about 4 million square miles. To have a person that I have a civil protection order against that lives in Washington to end up 3 feet from me, I didn't believe that to be something that happened organically. So when I did talk to the bouncers, my questions were more geared towards, okay, when did he get here? What time did he show up? How was he behaving? I wasn't asking questions. I'm confused about, after being constantly attacked by Mr. Roy for this whole thing, why he makes the assumption that I'm supposed to be helping him.
That's your response, that you were looking at from your perspective you said earlier that you were, he's the last person you expected to be there, so that's where your thought process was, why is he here?
Right.
And then you had the discussion about who needs to leave, and
And
that you just didn't feel like you had a duty to speak up about the bouncer.
Right. I say,
Okay, that's his response. He didn't.
I'm not objecting. I'll wait
Right.
for his response.
Yeah. Yeah, I mean, and I saw what the bouncer did in the video. They removed the wristband from his wrist. That bouncer doesn't work there anymore. He has since moved away. I wouldn't be able to ask him the question.
Okay, do you have any more questions?
Yes, I have another short little video clip to play, which I'm sure Mr. Pass is going to know about. Mr. Pass, please state why you lied about my probation, that I was not allowed to drink and or be in any bars, why you were actively present and stated that you knew the terms of my probation quite expertly. I'll remind you.
What is this guy's issue? I have a civil protection order against him, and so from my understanding, this thing's all 50 states. He has limited intelligence. He doesn't understand that he doesn't have one against me. I moved here.
I'm going to stop that video right there because that's my next question. Please state to this court at any time of the Dallas Bowl incident, have I ever stated that I have a CPO against you and don't understand that you have a CPO against me?
No, but let's say there seems to be some sort of confusion that the terms of the civil protection order also extend in the other direction. That if that they're competing CPOs, and that if I show up to a place that I normally go to and you're there and I don't leave, that I'm violating the terms of my own civil protection order. As it's not like that, and the situation was nothing like that. I went out to a place that I had started going to, shocked you were there, and so the whole incident just kind of happened. I mean, my contention is at any given time, if you seem to have understood the terms of the civil protection order, where it says that if we have an incidental encounter at a public place, you need to leave immediately. It states that. But you were arguing something
Where does it
different.
state that in the CPO? What page?
What page was that? It's Article 4. Page 6 of the CPO. It says respondent shall stay away from petitioner and all other protected persons named in this order and not be present within 500 feet distance of any protected person wherever those persons may be found or any place the respondent knows or should know the protected person are likely to be, even with the protected person's permission. If respondent accidentally comes in contact with the protected person in any public or private place, respondent must depart immediately. This order includes encounters on public and private roads, highways, and thoroughfares.
Well, Your Honor, we all know that's a lie because the necessity to rest defense. You can't say I'm wrong about that.
I'm not saying a word. Next question.
2 weeks ago, I'm guessing he found out, and he came down here because he's from Ohio. He's not even technically, I think, allowed to leave the state. He just got other.
You just said I was in the state of Washington, and yet you just said I just got out of the state of Ohio, and I quote, that I was still on probation and not allowed to leave the state. Will you please explain to this court what victim rights are?
That's overly broad.
Victim rights? No, victim rights is not broad. That means that they were told, and they had persons that knew that I left the state. So he knew that was a lie prior to me going down there.
After he got convicted for Megan Stark's civil protection order
It's
violation, I said
wrongfully
there was a follow-up hearing where the judge had put him on probation. My understanding of probation is that you have a probation officer that you need to report to in order to be able to leave the state in certain circumstances. And some people I know that are on probation aren't allowed to attend bars or drink. I was making an assumption.
And that assumption was wrong, correct?
I don't know if it was wrong.
You don't know when you were
You're saying it's wrong. I still don't know if it's wrong. You telling me something is wrong isn't.
Are you still
fact.
friends with DJ? Are you still friends with DJ James Firemouth? Yes or no?
Yes.
So you know that he frequents Orange Carpet as a DJ. Yes or no?
No, I don't know that.
Okay, because he's definitely seen me there. Let's keep going.
I don't
Yeah,
know.
it's a probation. And part of that probation, I don't think he's allowed to be in a bar or drinking.
That's all Ohio deal?
Yeah.
He's down in Florida? He's not gonna leave. The only way he's gonna leave is if he goes to jail. And I'm like, does this guy have a mental disorder or?
He's dangerous.
Whoa, 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 whoa. Did you just say I was dangerous, but
I
yet
believe
you
you
went and got on my TikTok? Yes or no?
Yeah, I believe you to be dangerous.
That's not what I asked. Did you or did you not, after stating that I am dangerous, according to you, get on my TikTok and like something on my TikTok? Yes or no?
We've been over this. I've explained it numerous times.
So you're stating yes. Cool.
Yeah.
Again, he not only came near me, why he thinks I'm dangerous.
I mean, liking on a TikTok video isn't technically coming anywhere near.
All right,
Did
you
you-
don't need to respond any further, okay?
Oh no, I got another question. So you're stating that the judge the judge that was on your case for the injunction of protection down in Florida,
Mhm.
you're stating that she did not state that you came near me. Yes or no?
I don't. She dismissed the case. If my understanding is of what I read, she claimed that she dismissed the case because it was not a domestic violence situation. That was my understanding.
Again, that's perjury because it does not state. It states the defendant's motion to dismiss was granted under FSA 3.190 C4 or uncommon as a C4 motion.
What's going on with him? How do you know him?
He was just another guy that went to another bar. He started harassing me and my friends.
Really, I started harassing you and your friends. Will you please state to this court how you and your daughter knowingly harassed, stalked me, and, mind you, falsely accused me of being some dude on Tinder because your daughter liked me and couldn't come up and talk to me? Yes or no?
Megan Stark is not my daughter.
Or Megan Pass, sorry.
Did you like him?
I never stated she liked me. I said she stated I liked her on Tinder according to you.
I don't remember ever saying that.
So you don't remember putting that in evidence to the CPO?
How would he know that you liked me on Tinder? You wouldn't. I don't even date.
Well, that's comical because that's in their CPO and then the Facebook message between me and Miss Pass. Because I already covered that too. Because you stated in that quote, I already knew that that wasn't you on Tinder and I handled that situation.
We eventually filed for a civil protection order, went from him because it got to be so out of control.
If it was so out of control, then why was I at Muddy Creek Saloon while you guys were there not starting any crap with you all? Yes or no?
That was prior to the civil protection orders being issued. When we went to Muddy Creek Saloon and you were there, I believe you were there with Emily Hartzell, you were on one side of the room, we were on the other, and so we didn't have any interaction.
You said I was on the other side of the room?
As best as I can remember it, and say you were sitting up against the wall, I usually hung out over near the bar. Those are opposite sides of the room.
You said I was sitting on the opposite side of the wall?
No, you were sitting over by the wall.
We went to court, judge heard the case, granted the civil protection order against him from me.
Really, y'all just went to CPO court and got a CPO against me? There wasn't multiple CPOs that Megan Stark filed and were, guess what, not granted? Yes or no?
So the whole genesis of this, I believe, started with Megan Stark filing a complaint for telecommunication harassment. When you received the complaint, you came down and you filed for a civil protection order, and then under the advisement of
Objection,
others-
Your Honor. He just perjured himself because I did not go anywhere to get a complaint. They sent Franklin County Sheriffs to my house illegally, as they're not allowed to do that without a court order, and there was no court order granted in 2018.
Okay, again, that's not a proper objection.
So after you had filed for a civil protection order against her, I believe that she did file for one for you, and then there was a hearing about it heard in this building. Megan and I actually came down, we were off work that day, so we came down for moral support for Megan. we actually didn't have any intentions of getting involved or anything. We were here for just moral support, but the magistrate on the case had found out that we were out in the hallway and called us in to be witnesses. So we came in to present testimony, under, the request of the magistrate on the case. And then after we presented, our testimony, within days, Mr. Roy filed a small claims case against us for harassment.
My daughter and a friend of ours. Since then, he's tried to sue us twice. Everything got thrown out. It's been dismissed.
Really, everything got thrown out and dismissed, yet Miss Stark at the time and y'all already knew that Judge S.A. Page had already reopened the case. Yes or no?
I did not know that. I saw that she had dismissed the case.
So Miss Stark didn't
I don't know that I don't know if the case is reopened or not.
Did
I
Miss
don't know to this day. To the best of my knowledge,
Did Miss Stark ever tell you that that case was still open and I confronted her with it on the stand? Yes or no?
No, we never had that conversation.
And yet you showed up at her sentencing hearing? Or sorry, my sentencing hearing for her?
Yeah. So you had just been found guilty in the court of law for violating her civil protection order. After.
So you're stating that I was found guilty legally and lawfully while a judge and a prosecutor failed to disclose that there was a mistrial due to the prosecutorial misconduct, witness misconduct, and judicial misconduct.
You went on trial, were found guilty by a jury of violating her civil protection order. Then right after that, we went out dancing. While we were out dancing, while you were awaiting sentencing, you contacted her again and sent her a message. She reported it to the police, and a bench warrant was issued. You were taken into custody. Then the sentencing hearing was scheduled at the time for you to be released like a month later. And yes, I attended that sentencing hearing.
So you know about the
I mean, conversations about other things.
You know so you know in the Facebook message that I sent to Miss Stark, you know what was said in it, yes or no?
She showed it to me. I couldn't tell you what it says now. Not something I carry around.
Have you or anybody that you know of on your Facebook or been tagged them and ever made a Facebook post about me before the CPOs were issued, yes or no?
Before the CPOs were issued?
Mhm.
Is this admissible?
It is admissible because in light of new evidence.
This has already been tried and ruled on.
I'm not going to grant a protection order against you if you said something harassing about him at that point in time, no. But you can answer the question. But what I said earlier is that it's not grounds for a protection order.
Yeah, I think that back then I had made a couple posts that I don't think that you were tagged. I don't think I ever even used your name.
Again, Your Honor, he's being unresponsive. I never said tagged me. I said tagged him, had been tagged himself or tagged with others.
Did you make any Facebook posts that related to him?
Yes.
Okay. This was before.
Yeah, see, here's the deal, is that he was harassing my daughter at the time, and I thought that if I could distract him away from her, he would leave her alone.
You stated I was harassing your daughter, but yet
Yes, you were.
you and your daughter
100%.
harassed and stalked me.
No, I say you were
So
harassing.
you denied coming.
No, I did not harass and stalk
You did not. I haven't got finished. You deny coming up to me with your daughter, falsely accusing me of being some dude on Tinder. Then.
Do what?
You and your daughter, did you or did you not come up to me with you and your daughter, falsely accusing me of being some dude on Tinder to see if I like Megan or not? Yes or no?
I do not recall any incident like that ever.
And yet it's
that doesn't sound like.
Okay, next question.
He violated the civil protection order against our friend. Ended up going to jail for 30 days. Got 150 days suspended. It's been a constant problem for about 3 years.
You only know him.
Constant problem for 3 years. Last time I checked, I knew you guys in 2017, so I was at 3 years in 2021. Mr. Bass?
Him and I were friends at one point in time until he filed the small claims case against us and I testified in the civil protection order hearing. That soured the relationship. So
Objection, Your Honor. We were not friends well before I filed anything for a CPO. Because they went around stating, and I quote, that I was fired from Tequila Cowboys when that wasn't true.
Somehow he knew you were here tonight.
My Facebook is private, but I think he was me and my friends listed as friends with him.
Like,
When I moved down here.
What does he have against you that he would come all the way down here and find you at a bar?
I don't know. I mean, I don't want to.
Did you or did you not just state that you think I'm crazy, yes or no?
yes,
You think I'm crazy?
yes.
Ooh. If I'm so crazy, why in the CPO against me does it state that I can have court-authorized contact via a subpoena, and yet you and your daughter and Ms. Stark all know that she did not comply with the comply with the subpoena that she was legally and lawfully issued, and know that she had to comply with?
How does that relate to
Me.
whether he,
Oh, because they're such good friends and they talk about everything. They've already confessed to that multiple times in multiple different court cases.
okay, but you start off saying, well, if you think he's crazy, then why? I don't understand how your question, I just don't
Okay, I'll
understand.
rephrase.
Okay.
Tell me how you think I'm crazy when, and I quote, I got 3 judges, multiple prosecutors, multiple lawyers, all thrown off my case by myself. While they were accusing me of being crazy.
I don't understand. Like, are you saying that a person that doesn't have some sort of mental illness couldn't do that? And say, I've watched a lot of documentaries that say Ted Bundy was an attorney, right? Proven to be a mentally ill person. And so just because he's capable of doing certain things, like, let's just be 100% clear. In some of his cases, there's been some requests for competency, okay? Personally, I disagree with the term competency. Competency to me would mean not knowing the difference between right and wrong. I believe Mr. Rohrig knows the difference between right and wrong. I do not believe him to be incompetent. I believe him to have some mental issues. That's my personal opinion. I'm not a doctor. I'm just saying some of the things that I have encountered and some of the things I read, some of the correlations I see him make are not things that I would expect from certain people. Somebody that I would expect to be
A rational
Oh.
mind?
right.
Okay. All right.
So,
That,
So you're saying it's irrational to file a subpoena and demand that it's enforced properly, yes or no?
I didn't say it was irrational. I was simply.
You said it was an
arguing
invasion
that
of your privacy.
I
That's what
was
you
right.
said.
That's what he
I was-
said.
I was arguing that you were taking advantage of the legal system to go ahead and file subpoenas to invade our privacy.
And yet you guys could have came freely to the prosecutors and corrected them on their statements. Have you guys ever attempted to do that?
No, I believe that Megan Stark, when she got her subpoena, the one subpoena, she actually contacted the police, and I think that you were advised to not go.
Yes, they told me that the case number, they couldn't find it, so they said I didn't have to go if I didn't want to. They also said that it was a legal gray area because along with the subpoenas was a handwritten note as well as his marksmanship record circled in other Facebook messages, so it was a hot mess of legal issues, so I just was told not to go.
Objection.
I did go.
Objection, Your Honor. Westerville told her that she did have to comply and that it was legal and lawful contact because it was.
Were you there?
I don't have to be there because it was on a police report. Evan Westerville
Okay.
had her.
She can testify as to what they told her. If you think something else, then you can
She
present that.
already. She again.
Overruled.
I did go.
Okay.
When I received the subpoena, I did show up, but I didn't bring the documents related to my home sale or anything that I felt was overreaching or an invasion of
Okay.
privacy.
All right.
And I did comply with the subpoena.
And
and did appear.
at the time, did you ever update your address when you moved out of the state of Ohio? Yes or no?
Absolutely not.
Okay, he admits that he never did.
Yes.
Okay.
And I'm
Got
gonna keep attack that again. So
No, we know he didn't update his address. Move on. Next question.
Okay. Please state how, if I'm keeping you from moving on, the rest of the people, say to this court, why is it that I had an appeal pending, went to Florida, and clearly was not down there to harass and stalk you as per the law?
Okay, so you're preventing me from moving on and say, let's just be clear, say, in preparation of getting ready for court today, I have had to spend the last 2 weeks spending every spare moment that I have preparing for court. I wasn't able to go out dancing. I wasn't able to spend time with my girlfriend. I wasn't able to do other things that I enjoy doing. My time had to be spent preparing for this. This is undesirable. I don't want to do this. I want to move on with my life. Now, as far as, what was the question about back when, what was the rest of that question?
The question was why having, sorry, not updated addresses. Oh, God.
Do you remember?
Yeah, so why, I said, how am I keeping you from moving on when you went to Florida and I had an appeal pending and I didn't go down to Florida to harass and stalk you?
Appeal pending for what? You had multiple appeals. Let's be more specific.
Okay, for the START case.
I don't understand the correlation that I didn't want to move on with my life because you filed an appeal. I'm not understanding.
I'm asking you, how did I keep you from moving on while I was awaiting an appeal and only went
So
and
how
only went to
are
Florida?
you preventing me from moving on?
Yes.
We're sitting here
No, I'm talking about in Florida, Bucko. I didn't say Ohio, I said Florida.
in Florida. So you violated my civil protection order, so I've reported it to the authorities.
You reported it to the authorities. You already knew about the CPO clearly by the body cam footage.
I still had to go down and file a report. I said they can't file the report for me off of the body cam footage. I have to go down and file the report myself.
Please state why in that video you never stated, and I quote, that you were told to leave.
I didn't feel it was relevant.
It's not relevant that you were asked to leave the bar? That's 100% relevant under premise liability, and you know that via the CPOs. Yes or no? Did you know premise liability?
We've been over this. He's testified that then they told him that they thought that you were right, that he needed to leave, but then they started second guessing themselves and they said, well, let's ask the police. And he decided he didn't need to volunteer since they were all going to everyone was going to sort all this out. His position is that then he didn't volunteer, that he was asked to leave first because he admits he was asked to leave first, but his testimony was, but then everybody decided, well, wait, let's kind of sort this out.
Yeah, they said, let's separate it. You go over to the billiards area, he's outside, you guys are separated, let's just
But
wait. for
is
the
your
sheriff to arrive.
position that at some point along the way, like when the police show up and everything, that he should volunteer, but hey, I was told to leave first, right? You
Yes.
believe I understand your point. You believe he still should have volunteered that so that you didn't look like the trespasser, the person that was being unreasonable. That's how he's looking at it. That all of a sudden everybody was looking at him like he needs to leave. He can't process why when you were the one initially told to leave, and he feels like you should have spoken up and volunteered that, okay? And we can go round and round about that all day.
And
But
not being able to move on, let's say with the appeal of him coming back down to Florida, I remember the question now. Let's say me not being able to move on, let's say, I was being contacted frequently by the prosecutor's office updating me on the progress of the case. During those conversations, the prosecutor was passing messages along to me that Mr. Rory had given to them to give to me.
Objection, Your Honor. Hearsay and
no.
for proof of.
He said-
Call for proof of. Prove it. Hearsay. They're not here.
all right, let's just move on. Sustain, because I had a lot of hearsay has not been objected to. Some has, but that would be hearsay. Okay.
Mr. Pass, please explain to this court why the courts have never been able to prove legally and lawfully that I am mentally ill, but yet you think I'm crazy.
I think that I'm supposed to explain why the court wasn't able to do something? I'm not understanding.
Okay, I think he's already answered that. His position, he admitted that
Okay,
he
Your
doesn't
Honor,
think
I'll
you're legally
I'll
incompetent.
rephrase. You stated that you think I'm crazy, but yet you disprove any and all mental health orders that have ever been granted against me before.
I do?
You guys
What's
don't
your
like-
question? He disproves?
Yeah, he disproves any and all mental health orders that have ever been ordered against me.
I don't know what you mean by he disproves.
Okay, well, I'll rephrase. Mr. Pass, have you guys ever been in possession of my DD-214, yes or no?
The what?
My
I think
DD-214.
that you provided us with some documentation about your military background, say the marksmanship medals that you received and your discharge paperwork.
That's my DD-214,
Yeah.
discharge.
I didn't read it.
I didn't ask if you read it, I just asked if you received it.
Yeah, you gave us discharge from the Navy from back in, when did you get out of the Navy? 2014, 15, 16? I don't know.
Anyways, next question. You also contacted, or somebody in one of your co-petitioners and co-respondents in several cases reached out and contacted my ex-wife, yes or no?
Yes, let's say Megan Stark reached out to your ex-wife, yes.
So Megan Stark reached out to my ex-wife while liking me and falsely accusing me of things, yes or no?
Liking you.
Yeah, she already confessed that she has liked me before.
I don't remember that.
A Tinder match? Like, we could be here all day in the Valentine's Day thing. But it's cool, I'll move on.
That sounds like a question more for Megan Stark than me.
It's cool, I'll just move on to the next question anyways. So you've already admitted to having contact with my ex-wife. Will you
Yes.
please explain to this court how it's not possible, according to any court, that you said has granted a mental health order against me or mental health assessment against me, has literally stated, and I quote, there was no way possible, according to what I allegedly said to them about my military record, that I never would have been able to meet my ex-wife.
What?
What are you asking him?
I'll rephrase. You literally confessed that I had an ex-wife, yes or no?
Yes, you have an ex-wife.
And no one has ever divulged to you that literally proves that everything you said about me being crazy or anything being found in court about that wrong. No one has ever told you that.
What?
Sir, your question doesn't make any sense.
I'm asking if he's ever been disclosed by anyone or any entity like a prosecutor, a court, that literally they stated that there was no way possible that I would have been able to meet my ex-wife by what they stated against me in any mental health assessments. Yes or no?
I wasn't present during any mental health assessment. I didn't perform it.
Well, so you guys are denying ever being told about any mental health assessments or orders or anything?
We
that
could
said-
see through the court system that a mental health assessment was ordered, issued,
Yeah, we
and
were told what
resulted in.
happened.
So you're
you ending
denying
up
that
in
Mrs.
Twin Valley Mental
So,
Health
so, you,
Facility.
so you're denying that Mrs. Keck told you that a doctor said I was mental?
I didn't have any contact with, I've never spoken with Ms. Keck. Ms. Keck was the prosecutor on my daughter's case. I've never had a conversation with her. My daughter has. I have not.
That's
The
my next.
extent of my knowledge on it is I could see from the court records that a mental health assessment was ordered, performed, and the result of it resulted in him being confined to Twin Valley's mental health.
Objection, Your Honor. That is not true.
All right, but you're the one opening the door, asking these questions.
Okay,
Okay,
well, I'll ask another question. Mr. Paz, was I ever found guilty of any crimes in Florida? Yes or no?
Were you ever? No, it never went to trial.
I said found
So you were
guilty
not-
of.
You were not found guilty of any charges. in
Again,
Florida. You were charged with crimes. They did not go to trial. They were dismissed.
Again, I'm going to restate the question. Was I ever found guilty of any crimes? Now, I'm going to note this again so you don't mishear or misinterpret what I'm saying. I'm not stating any crimes that you alleged against me. I'm stating, have I ever been found guilty of any crimes in Florida?
Found guilty? No.
So you're stating that Judge Jeske didn't recuse himself because he threw me in jail for 60 days illegally?
I don't know that.
But you do know
I was present during the hearing. You were very disrespectful to him. You were talking about performing a citizen's arrest on him, and he found you in contempt of court and put you in jail.
See, he just lied. He just knowing he lied.
It's in the documents.
A direct criminal contempt of court is a criminal charge.
Okay, well,
Jesus
all right.
Christ.
I was present.
So you want him to admit you were found guilty of contempt?
Yes, that's what I was trying to get him to state.
Does he know that?
He just stated that he did. After he stated no.
Criminal contempt? Okay. I took your question to be about criminal charges and criminal contempt charges that are a very specific subset, so.
No, I kept it very broad so it wasn't confusing.
Okay,
him
all
to-
right. He got you, okay? So you knew about his criminal contempt. He got you.
He was
Yep.
released early, I thought it was dismissed.
Okay, all right.
So
Just
he-
letting
he
you
was
know.
sentenced like-
Okay.
He was sentenced like 60
All right.
days after 45 days he was.
Okay, next question.
And that leads to my next question. You just stated that mental health assessment sent me straight to Twin Valley for.
I didn't say it sent you straight to Twin Valley. I said it resulted in you being sent to Twin Valley.
That's not what resulted in sending me to Twin Valley. So I'm going to ask you again.
Okay. That was my understanding.
That was, okay, that's all he can testify to. If he's wrong, he's wrong.
I mean, it's a fair assumption.
You stated that I've been banned from multiple bars, yes?
Yes.
Please state, and I quote, how I was not banned from Muddy Creek Saloon, nor did you ask anybody to ask me to leave the bar while you were stating I was harassing and stalking you.
This was before the CPOs were issued. We had things going on. I just stayed on one side of the bar while you stayed on the other.
And
I
yet,
don't know what your status was at Muddy Creek after the CPOs were issued. From what I understand, you've been in contact with the owner of Muddy Creek. Muddy Creek is now, to my understanding, closed. So we wouldn't have the ability to be banned from Muddy Creek unless they reopened or opened up a new bar under a new name or same ownership of a different bar. But you being banned from Muddy Creek? No. I know you were banned from Granero, Tequila Cowboy, The Bank.
I was banned
Eagle
from.
Creek.
Hold up. I was banned from Granero Lounge?
That's what I was told by James.
You were-
You have that, you've used that communication with James in lawsuits. Just so you've read it. Kyle's not allowed to come here anymore. I said, to me, that's.
Again,
my
that's a
understanding
false
is that
assumption.
You were banned.
All right, Mr. Pass, that is your signature, correct?
Yes.
Did you know that under ORC 4705.07 that even just putting that signature down makes you in direct violation of that ORC unauthorized practice of law?
No,
You didn't know that.
no. I made a motion with the court. We're in court today. Let's say
Please state to
I'm
this
I'm
court-
representing myself.
Please state to this court how long you have been a notary in the state of Ohio and then in any other state as well.
My notary expired in 2019 for the state of Ohio. I don't live here anymore.
And I said
I moved away from Ohio
in
in
any other state.
2020,
And I stated
2019.
and I stated in any other state.
I don't have a notary in any other state.
Again, that's why I asked the question. So you know as
I
a
am pursuing a notary in the state of Florida.
Okay, all
so
right.
you know as a licensed notary, and we're trained and tested according to the state of Ohio that you are not allowed to put your name down on any documents like that in any court case.
Well, I didn't notarize the document.
It doesn't matter if it's notarized or not, Bucko. Does not
Well,
matter.
under our civil rules, even pro se parties have to sign legal documents.
Oh, I know they have to sign legal documents,
Okay.
but literally, and I'm gonna be quoting Judge James Green on this one.
I'm a little confused to say, he put his mother's name down on the civil protection petition that he filed here. How is that any different than what I did?
Because
I'm a little confused.
Okay,
because
all
I
right.
never stated
It's,
I was representing.
he can include additional people that need protection. He's not engaging in the practice of law doing that. If you made a court filing and because you said I, Steve Poss certified, but if you said that I, Steve Poss, behalf of myself and on behalf of other people hereby make the following motions, you can't represent them, okay?
Okay.
But this, we're talking about his signature, okay? That's not he's not signing this as a notary. He's signing this, I think it's still Rule 11 off the top of my head, that all filings have to be signed by either the attorney or by the party making the filing. If this wasn't signed, then I would strike it from the record. So it's,
All right, Mr. Paz, you and everybody else asked my mom, your daughter stated to the court that Florida had nothing to do with my alleged violation of CPO to her. Will you please state, and I quote, why, according to this court transcript, labeled State of Ohio v. Rohrig, 21 CRB 003653, April 8th, 2021, Judge O'Grady's courtroom, Miss Amy Myers from the City of Columbus Prosecutor's Office, representing myself. States, and I quote, I was told that he went to Florida to harass or stalk the father of the victim. Yes, there are three victims. The three victims.
Testify why Amy Myers said something.
Again, I'm gonna ask you a question. I'm trying to read so I can give you the layout. Jesus.
okay, he's laying a foundation for what hopefully is a relevant question. Go
So
ahead.
please state to this court why it literally states that Florida was directly involved. The message states that Florida was directly involved, and that you guys failed to state and conjoin that Florida was directly involved. Yes or no?
I can't explain why Amy Myers said something. I'm not Amy Myers.
I've never asked why Miss Amy Myers said that. I asked why you all failed to state that Florida was a part of that case and conjoin that Florida was a part of that case.
I don't believe we were at your arraignment. That's from an arraignment.
I
right?
never asked that arraignment. I'm
So
talking.
you're saying that you thought at some point they had to do you just to pull up to the courthouse and say, wait, you need to know these facts.
That's not
Well,
what I'm
then
saying.
when should he have brought that up?
They didn't know how to contact the prosecutor's office.
Okay, so that's your point. So at no point you decided you didn't pick up the phone and contact the prosecutor. You just didn't.
I'm not.
Do you have any
I was
explanation?
I've never had contact with any prosecutor in Ohio on any of these cases.
Okay.
I had contact with my prosecutor down in Florida.
I will restate again then. You never contacted any prosecutors stating exactly that Florida was a part of that case.
I haven't had.
No.
I haven't had a single conversation with any.
So no,
prosecutor
you
in
didn't
Ohio.
do that then.
No.
Yes.
Okay, that answers his question.
Oh, that's all questions for now, Your Honor.
Well, that's it. This is your time to cross-examine him. All right, here's the situation. I can't in good conscience keep going. I was trying to get through Mr. Pass because he came up from Florida. I have you two that have an adorable child that's been held captive here all day that I don't know how much longer she should be expected
To last.
to, right? I have you, Miss Stark, who clearly has blood sugar issues. We all agreed to power through lunch. It's now dinner time. I can't in good conscience keep asking you to stay here, okay? So what I need to know is, we've got through Mr. Pass's case, okay? So I've got that. What I still have left is your defenses. If you want to put on a defense, okay? Because under the law, you can choose to just stand on and let me evaluate the case based on the evidence he presented, or you can choose to present a defense. If you want to present a defense, given the timing,
Can I ask a question?
yes.
Are we allowed, as our defense, to request a motion that this filing be dismissed because he hasn't presented actual
You can
evidence?
yes, you can make that motion. That's your time to do so now.
I would like to make the motion that he has not presented any evidence of a threat or harassment against him by either myself or Jeff James.
Well, see, here's the deal, because that's
Me,
that.
not Jeff.
Yes. So,
Okay.
Mr. James, are you making that similar motion? Yes,
I'm
ma'am.
making the same motion.
I'd like to present a defense. I'll be as quick as I possibly can. I can't speak for how long the cross-examination is gonna take them.
His cross, I think she meant.
I understand. What I'm saying is,
I don't believe that he's provided any evidence that I stalk or harass him or
are you?
any kind of threat or danger.
Objection, Your Honor. What I was going to say in cross-examination with Ms. Pass and Ms. Stark is ask them why they brought two males to a court proceeding outside Judge Hummer's courtroom to blow kisses and wave at me.
Hold on. I need to know. Are you making the same motion before I make a ruling, or do you want to present a defense?
I will make the same motion.
Okay. All right. To address that point, when you put on a case, if there's relevant information that they need to your case in chief, you could have called them in your case as on cross. You chose not to. You wanted to wait till they testified so that you could then cross-examine cross-examine them and elicit some testimony facts that you think would be helpful to you, yes? But they're now moving to dismiss, okay? Because you didn't call them in your case. All right, I asked you if you had any further witnesses. You said no.
Because I'm not allowed to call them as witnesses.
Yes, you are. You're allowed to call them as if on cross. You absolutely are. So they're choosing not to put on a defense, okay? They're moving to dismiss.
So, Your Honor, you're stating that the United States constitutional right to not self-incriminate yourself is literally not upheld in this courtroom.
I don't believe that's what I said. What I said is they're moving to dismiss.
If I call them to as witnesses for me while moving for a textual order against them is illegal.
This isn't a criminal case.
Doesn't matter if it's criminal or not. It's in all cases.
What matters is they have a right not to incriminate themselves. If you had called them, they're free to invoke that Fifth Amendment right, and I decide if it was properly invoked. That's how that process would have played out. Okay. Do you have a response to their request for dismissal based on insufficiency of the evidence? And I'm talking about these four, because Mr. Pass put on a defense, so I'll evaluate
Yes,
the
Your
merits.
Honor, they were not only Brady's rules and Galio's rule witnesses, they also failed to disclose that they could see my Facebook post. They clearly went out and got a bunch of information to libel and slander my name, including going out to Washington State. On top of that, and I quote, they, again, have brought people to the courthouse, falsely accused me of crimes that I was not found guilty of in multiple different states. That has been seen by stalking because I did not go near Mr. Pass. Mr. Pass came near me, and I could even provide the dismissal that states that. On top of that, they caused so many other crimes instead of showing empathy and sympathy when they were to show empathy and sympathy and put Mr. Pass out on the street, technically. Because they did not turn against Mr. Pass when they had no choice to and state that a bunch of stuff that was not said and spoke up on my behalf, they allowed me to be thrown in and out of jail. That's mental, emotional, and physical distress. On top of that, they even tried painting it as me just doing and acting strangely when Judge O'Grady and a bunch of other people were not doing their jobs, and the victims were not, alleged victims, sorry, were not applying or complying with the subpoenas, as well as bringing people to harass and stalk me.
Anything else, sir?
Oh yeah, there's also the due process right to a complete defense because they have a witness that they want to call that I don't even know his name or how he's relevant to this case.
Okay. Is that it?
I'll rest at that for right now.
Okay. So, for purposes of making my ruling, I'm going to admit all of Mr. Rourke's exhibits because, you know, fairness to him, like, I'm considering all of the evidence he presented and his exhibits, okay? So they're just all going to be admitted for the record as pertains to you, the four of you. So Rule 41B2 does allow the court to issue, to dismiss the case once the petitioner has put on his case, if I find that he's not met his burden of proof of demonstrating that the four of you engaged in what the law defines as menacing by stalking. What I have to do is, my ruling today is only a written recommendation. I actually have to put it in writing. It will be reviewed by Judge Holbrook. So because of that, I'm going to make a written finding as to the basis for my ruling today, but I do find, sir, that you have not met your burden of proof as to the four of them, okay? Because I understand why you're here. I understand everything that you're alleging that they did. Even if I believed that they did all of these acts, under the law does not protect business interests, rights of association, reputations. Even if they made false statements under oath, there's other remedies for that, okay? Everything you've alleged, none of it meets the criteria for what we call menacing by stalking, okay? It's a very specific act that you're here on. You can't just come in here and prove that they commit this wrong, this wrong, this wrong, okay? It's got to be very specific wrongs that have to be proven to meet the definition, okay? And like I said, what I'm doing is just making a written recommendation. So I'll explain all this more eloquently in writing. It will go to Judge Holbrook. He'll review my findings. He can accept them, modify them, or reject them. What he decides is the final decision of the court, okay? That review process could take a couple of weeks. You'll get copies in the mail, okay?
Can I change the address where they would be served? So
Yeah, that is a question that we do have, is that we would like
Yeah, before-
In speaking with my aunt, who works with the attorney, he did recommend updating our address with the court so that he couldn't
Okay, but-
send notifications or service to addresses where we do not live or work. However, at the advisement of the prosecutor in the case, she recommended not doing that because he represents himself pro se, which would give him access to those addresses, and if we don't want him to have those addresses.
Objection, Your Honor, they're failing to state that she stated I'm required to have their city and state addresses at minimum.
Okay, what I'm going to do is, because you're worried you're not gonna get the court's decision, before you leave, I'll just have you write down what you believe is where you want it sent. And I would do the same for you, okay? Like, just write down for me the mailing address that you want the decision sent, okay? And then the,
Doesn't have to be our address, it's just an address we can give you that we can be assured that it would be delivered.
yes,
Okay.
yeah, we can do that.
Well, they're gonna have to provide addresses for the appeal, because that's gonna be filed tonight, so.
Well, you can't sorry, I can't give you legal advice, but it's not done yet. That's why I explained to you the process. I still have to put all this in writing. Judge Holbrook needs to sign off on it. Maybe he won't, okay? In which case, we'll be back on here and they can
Well, I
present their
already
defense.
objected and asked for a continuous under Ohio Judicial Conduct Rule 2.11, so.
Okay, well,
Question
So-
regarding that. If we do have to come back, is there a way that I can attend via Zoom like you have explained?
anybody can appear remotely, especially if you live out of state. That's a valid request. But yes, we can make arrangements if we have to come back here. Now, I do have one last thing though, for the record. Mr. James, you still have a case pending, okay? I'm gonna be honest with you. Want to talk to you about that, okay? Because I had the advantage of being the magistrate who, because I don't hear all the ex partes, like I didn't hear your ex parte request. I actually heard his ex parte request. I denied the ex parte request, but I did put it in for hearing today, okay? But based on what you've alleged in your petition, you do understand, same rules apply to you. You have to prove menacing by stalking, not that somebody's harming your business interests, those kinds of things, defaming you. If I hear a lot of testimony about that, it's probably going to be the same result. Do you understand that you would need to prove to me that he's making actual threats of physical harm to you or causing you mental stress? And the mental stress can't be that he's sending emails to your business partners and you don't like that. It has to be that he's constantly berating you, constantly contacting you individually. Do you understand what I'm saying? Do you want to go forward with your case? Because if so, we're going to have to pick a new date.
Can we refile it?
Yeah, you can dismiss without prejudice.
Okay.
I would be fine with making that motion and, just ask, again, what we stated in the testimony is true. It's been years that we've seen Mr. Rohrig.
Right, and that's because I did hear your ex parte. That's what you told me. You haven't even seen him for years, which already sent red flags as to, okay, can you prove this man is menacing you by stalking if you haven't even seen him in 5 years? Do you understand what I'm saying?
Can I ask a question for clarification? I know that there can be a difference between physical stalking and online
Yes.
stalking. In regards to any actual danger posed, I believe that our petition, since I'm listed on there and Lola is as well, primarily rested with Mr. Rohrig's threat to have Lola taken from us.
And see, puts the court in a bind because, of course, I'm not hearing that as evidence. I don't know if you made that threat or not, but I understand what you're telling me, that when somebody, but because I get cases like that all the time where what I'm hearing is somebody's calling children's services and making false reports and stuff. That, again, that's a defamation case. That's an abusive process case. Any parent would be alarmed by such a threat. But what I will tell you, any order you got would just be a no contact order. Just like you explained that Magistrate Erdy told you that there's certain things she can't bar you from doing.
Right.
I can't write in there and don't make.
I wouldn't
right.
be as concerned with him defaming us to Child Protective Services.
I hear you, but I'm just saying that
More
I couldn't get that specific with it
Yeah.
to say that. Like, there's no order I could put on that would prevent him from tomorrow calling children's services against you if he chose to do that.
I don't even worry about that because
Right.
I'm convinced that our care of Lola is exemplary. My when you make a threat like that to a parent, it is concerning. When it's a child like Lola, that can be a life-threatening situation. She has seizures that only her immediate caregivers can recognize. My only concern is.
Objection, Your Honor, relevance, because they have to prove that I even knew about her condition before today.
No, I mean, I understand your point, okay? But, you know, having said that, what I'm telling you is that you'd have to prove certain things, okay? The direct contact from him, if he's telling people, you know, I'm gonna ruin their reputation, I'm gonna have their child taken away, that anybody would be concerned about that.
Right.
I'm not saying that that's, if that's even happening, I'm not saying you did it, I'm just saying, I get what you're saying. I'm just saying that I don't know, I can't prejudge your case, okay?
Right.
I hear you. What I'm telling you is based on what Mr. James came in and presented during the ex parte, I do have serious concerns whether your case would meet the definition of menacing by stalking. That's why I'm asking you, if you still want to go forward to prove that he is engaging in menacing by stalking, we need to pick a new date for that. That's what I'm asking you.
Dismiss, assuming that we don't end up.
And Mr. James, you were technically the named petitioner, although,
I will motion to dismiss and just plea that, again, we still don't know why we're here. And again, he's smiling, and I'm just gonna leave it at that. We will move to.
I will say that most of your evidence was directed against these three, okay? So already, again, that's another reason why your evidence against the Jameses was woefully insufficient, sir. It just was, okay?
So thank you, yeah.
Right.
Motion to dismiss
So,
ours.
so your case was dismissed without prejudice
That's
to refiling, okay?
That's fine.
Based on your motion, okay, thank you.
Thank you.
All right, so the last thing for the record, you guys can start packing up because this is mostly involving the two of you. Because you put on defense, I've got to make a decision, okay? Mr. Work, do you have an objection to Mr. Pass's exhibits being admitted into the record?
Nope,
No?
no objections at all.
No objections? Okay, so those will be admitted and considered. Then same thing, I've got to make a written findings. They'll go to Judge Holbrook, same process, okay? Thank you. I'm going to close the record.